Hey, Tom.
Hey, Paul. I see it's trying to contact Pablo.
Yeah.
Oh, nope, there she goes again. It says busy. Huh. That's weird.
Same problem.
Are there any standardized settings she may have off for her status?
Good question.
Being up to date. Being up to date is one of the best things, or worse, depending on how they're doing at the moment.
Okay. Well, maybe we should just go ahead. I don't know.
Sounds good.
Maybe she can try her cell phone and try to just join with the join button. And if she has multiple devices that can do Skype.
The texting, she said she's in.
Oh. Oh, yeah, texting she is.
Well, she's in the group. That doesn't mean she's in the call, yeah.
Right.
Well, I think we just need to go ahead. I'm sorry that she couldn't get in the call.
I know, we do that every time we have more than two people in a call. That seems to be what we have to do. I've done it to Dan dozens of times.
Yeah, I regret it, but
everybody.
see, okay, well, let's just.
So if someone would mention to her that if she has a cell phone or something like that and signs in, she can probably be able to join right as we're going.
I did suggest that to her in the chat. I said, Pablo, can you try using the join button?
On her cell phone. The device that she's trying to use obviously has a problem.
Yeah.
That's why I thought maybe the cell phone would be better if she has a smartphone.
I'm texting her right now.
But
just
I don't know.
Okay. All right. Well, let's just get going and anyone, if you want to throw something on the chat, if you have a comment, I'm recording the video off the chat. Since I just signed off the mobile, as I think it's the problem. Okay. Well, do you want to try one more time then, or?
You want to try?
Let's see if she can just join, because she should be able to join just fine. I've never,
Okay.
The people who can't answer also can't join. It seems to be a related problem.
Right.
And I think it's related to how the firewalls in between the two of your computers work. And since we've tried two different people to host it, I think it's that she's buried behind a firewall that's not very, permissive.
Maybe. Well. I think we should just get going, man.
Yep.
Okay. So I don't want to try to make any rules, but just if you want to, anyone that wants me to stop the recording, just say something like stop, pause, and I'll stop the playback and jump in with your comments. And
if history's any example, it'll be pretty much after everything they say.
Yeah.
Well,
one sentence is about all we get out of them before we have commentary, right?
Right. Well, that. So be it. And let's just. I'm going to start the recording here, and let me know if you can hear it clearly, and we'll go from there. Huh. Wow. Now I can't even hear it. Wait a second. And I'm a little. Oh, wait. I'm sorry. Not a problem. Hang on. Here we go again. Sorry about that, guys.
This court of the city of Waukesha, sitting as a municipal court for the town of Lisbon, is now in session. Appearances, please. Okay. Thank you, sir.
PaulMozina.
I just want to pause it there and mention the prosecutor has her microphone turned off and she turns it on very quickly. But what the judge just did was he asked for appearances. And I was naive or ignorant, I should say, of the procedures. and that was my opportunity, as Mark Stevens points out, to challenge the appearance of the prosecutor, asking if she represented anybody but herself, if there's any evidence of a complaining party. And I missed that opportunity. That was the classic point to challenge the prosecutor's appearance. Did everybody get that?
Yeah. And one other thing, too. This is supposed to be a Star Chamber hearing, but yet he called it a municipal court hearing.
And state your own appearance as well. Right.
He does ask me for my appearance, but when he asked for her appearance, it was the use of the word appearance there is very telling.
But it's not like it's not like you forever waive,
Well, good point.
the issue.
Good point. Okay, let's go.
Thank you, Mr. Zeno. Mozina.
Yes, sir.
Well, I'm going to try.
Mozina.
Okay. For the court today is a traffic ticket, a speeding ticket, 19 mile 49 and a 30, 19 miles over the limit. It's a 4-point ticket with a fine of $119. Do you understand, Mr. Mozina?
Well, sir, I'm not an attorney.
I understand.
I have a few questions.
Do you understand the ticket?
I have a few questions that I'd like to clarify these proceedings before we continue.
No, I asked you a question. Do you understand what I just said with the ticket?
Well, can you repeat that?
Okay. The matter before the court today is a speeding ticket.
Okay.
Alleging that you were going 49 miles an hour in a 30-mile zone, which is 19 miles over the limit. That is a 4-point ticket with a fine of $119. That's why we're here today. Okay? You understand that?
That's the allegation made in the citation. That's what you're repeating. Is that correct, sir?
That is correct.
Okay, there's an allegation on the table.
I just want to pause it and say that I attempted to get into the set of questions there, and
but you weren't very interested in clarifying anything, right? You said, "Well, I have a few clarifications on that, so I'm trying to understand that." Do you understand the fundamental concept of what understanding something means? I mean, I know in the not in the vernacular. I don't mean in English sense. I mean in the sense of formal.
Well, I think I do.
Okay. So really, when he asked you, do you understand that? The first instinct I have is, well, I'm trying to. I'd like to clarify a few vaguenesses.
Well, that what I'm pointing out is I tried to do that, and he just cut me off. I didn't
hear you trying to do that. I heard him cutting you off, but I didn't really hear you trying to do that. I mean, I get that you wanted to, and that he was stomping on you before you even had a chance to. And I get that it was in your head, but what I'm getting at is it isn't on the record. It isn't on the recording.
Okay. All right, let's go. Wasn't persistent and forceful enough in requesting clarification.
And I'm trying to point to the difference between your perceptions internally and what comes across externally.
That's fair. Got it. Okay.
Okay. Now, before we go any further, I have gone through your file. And in the file, Mr. Mozina, there is a letter from you, a motion from you, an indication from you that previously you wish to withdraw the not guilty plea that was entered on your behalf by Judge K. If you do that, then this court will find you guilty. I will assess 6 points against your driving record and levy a fine of $119. The matter is done. Now, do you wish to proceed with that request that you made to the court?
Let me clarify that, please, sir. You're saying that if I file a motion to vacate the plea that was made by Judge K, then what are the ramifications if I
why didn't you say to my detriment? Why did you shy away from being clear, Paul?
Good question, but because I was flummoxed.
Fear. I mean, I'm trying to draw your attention to the fact that fear stopped you from saying things that were effective. Not that what you said was ineffective. I'm just saying you didn't go to the maximum effectiveness because of fear. Because you stopped shy of things that would insult him and make him angry. Right?
Well, another way of looking at it was that he presented Gary, you've made this point many times. He presented only two of many possible options. Yes. He left out the option that I could challenge jurisdiction, and I was completely.
He was specifying how he would react. Right? He said, if you do this, I'm going to react by doing this, and it's a conditional deal. It's like, but why is that a condition? Of course, clarifying is what we're going to get to. Clarifying, why is that true? Why is it just because I undo somebody else's injury that you're going to injure me in a different way? Right? And I know this is in your head, but what I'm trying to say is it needs to be more than just in your head and in your heart. It needs to be in your voice,
Right. My point was just that I never heard that response. It threw me. It threw me for a loop. Maybe it's too easily done, but you could tell from the sound of my voice. I'm like, what? I can't.
Well, yeah. Again, when the word what the F, when WTF is in your mind, objection, point of clarification should be in your voice, right?
Mm-hmm.
And you didn't do that. I mean, all this practice and all this kind of gearing towards when someone throws you something that's messed up, objection, point of clarification.
Mm-hmm.
Hold on. Then you can back up and you can say, wait a minute, let me make sense of this. You're saying that if I try to undo this injury done by somebody who is overstepping, my wishes and my goals, that you're going to overstep my wishes and my goals in the other direction. You see, it would have given you a chance to step back and clarify that, right?
Yeah. Well, let's listen to
it.
Then. But it was not a good shining moment for me, no doubt.
No, but again, the fear was stopping what should have been at the tip of your tongue from coming out, and I understand that it happens to us, and that's the whole point to the Arraigning Mr. Target video, to teach to kind of show people, it's like, I don't care how much practice you have at this. When he's there, something deep in you is going to say, don't piss him off. Don't piss him off. Whatever you do, don't piss him off. You're better off going to jail paying the fine than pissing him off.
Okay, let's go.
Okay.
And the matter will be over.
So if you will find me guilty, is on what grounds, sir?
Sir, when there is a ticket, an allegation, you have to enter a plea. If you don't enter a plea, the court may enter a plea for you. That is by statute. Okay?
So if there's an allegation...
Objection, point of clarification should be coming out of your mouth right now.
Right. I didn't use that OOP-OC. You're right.
Why not? Because you were afraid.
No, I was just being more conversational because
that's a wholly. See, again, you thought you'd be able to approach this as if you were on a couch in a coffee shop, and really you weren't. You know what I mean? It's got to be more. It's got to be he's formalizing, and he's using formal structure to screw you over, right? And I'm not a big fan of ceremony by all means, but you've got to at least do the same thing as that. And you're not, you're just like, okay, but you'd at least have to say, if that's true, how can you protect what's right and wrong? Are we disregarding ethics? We'd have to get into a whole different conversation than you're going to, because that's going to piss them off even more than the formality, you see.
Oh, yeah.
Mm-hmm.
Okay. And Mark is the one that got it through to my head. If you don't object, it's like you're agreeing. You can't. You can't.
Every silence is an agreement. Anything other than there's only two things: is point of clarification, and I agree wholeheartedly. That's it.
Yep.
Nothing else is really relevant.
Mm-hmm. Okay.
What's required to enter a plea as an allegation? Is that what you're saying?
Yeah, they are alleging you did this. If you wish to challenge,
excuse me. Let me write that down. You're saying that if there's an allegation against me, I have to enter a plea.
That is correct. You have to either admit it or deny it.
Let me write that down.
But you see, you don't clinch it. You don't say those. So you have no concept of challenging or demurring or having no jurisdiction at all. You stopped shy of that. You see, there's a fear, and I know it because these are things that have to be that would be in your head if you weren't afraid. You know what I mean? And not to judge you, I'm afraid in front of a judge as well. They're vicious, horrible creatures. You know.
Yeah. Okay.
So can you please go into detail about the demur and the challenge versus
he just said you have two choices: admit or deny, and that's not true. And okay, it's like, well, okay, you're telling me I only have two choices: admit or deny. So in your presence and under your, force here, you're going to deny me the ability to do anything but those two. Any other challenge, any other question, any clarification, any point of clarification, any question at all. And you've got to get him on the record as saying, I'm denying you information. That's what we're getting at. But you're not going there at all. You're just, you're just letting him do what he's doing and saying, oh, that, by the way, you're doing what you're doing. But not underscoring it with, you're denying the information.
Okay. Good to go, Joe?
Yeah, I'll just put it in the chat box. Thanks.
Why did they call this a star chamber? I'm curious. That's the second time I've heard of it.
I don't think they called it a star chamber, did they?
Paul?
No, I got that from Stahl. Stahl posted a link of Mark and Kelvin, I believe, doing a role play with Mr. X, and they mentioned Star Chamber, and that was after I heard Gary mention Star Chamber once upon a time, and
Caleb actually was in a star. His last hearing was considered a Star Chamber hearing. That's what I thought you had said. Never mind.
It's just a metaphor.
No, they wouldn't confess that.
They did with Caleb. They told him straight out that's what it was.
They said this is a star chamber?
Yeah, that's why it blew my mind. I mean, Caleb and Scarlett.
This is a star chamber.
No, are you sure?
Well,
yeah, that sounds like an allegory gone wrong, right?
Star chambers are like secret,
That's why it was so amazing to me.
Hey, Star Chamber. Hey, it's Fabrice here. I'm just jumping in from the UK. Star Chamber. It comes from Spanish religious court. It was kind of one of those you dunk it or you die. You float if you're not. You sink if you're not a witch. You float if you're a witch, and we'll burn you if you float.
Yeah, we've been down. I mean, we've been talking about it for a day or so now. It's just that I didn't think anybody had ever. It'd be a mind blowing confession if they said that they were actually that.
Well, I'll get a hold of Scarlett and Caleb again and ask them, because they're the one that brought it up. And I don't see why they would have brought it up if that weren't the case.
Well, we were talking about
what? I was just going to say, sometimes when I'm in court here in the UK, it feels like a star chamber. It feels like they're logging everything up against you, which is a little bit about when I picked up the conversation. If you can say, not good, I object to this. This doesn't answer my point of clarification. That keeps them on the button, and that's what stops it being a star chamber. Otherwise they'll just throw accusation after accusation.
Mm-hmm. Okay.
You have to either admit it or deny it.
It doesn't look good if they deny, answering a question. Hey, I was 100 meters in front of Buckingham Palace. I had this cop in front of me. He said, I'm going to take your mask. I'm going to take your sign off you. Okay, just a couple of days ago. And I said, okay, you take that. You do that. I've got a question for you. Under this legislation, can you take that away from me? Answer my question. And he didn't answer the question.
You sure got him. Cool story, bro.
It's master and slave. If you keep asking the question and they walk away and the question isn't answered, it speaks for itself.
Mm-hmm.
You know, it's when they burn you to not ask the questions. You know, it's when they give you a hard time. It's when they make it feel painful. It's when they go, hey, Paul, you know, it's going to be so socially uncomfortable for you to ask this question that you don't want to ask it. You know, ask it anyway. And that's how you break a star chamber.
Right. Okay, let's pick it up.
Yeah, can I ask
You don't have to repeat that, sir. I'm on the record as acknowledging you are.
I understand.
Please don't waste your time or my time.
I didn't finish my thought, sir.
No, I'm finishing your point. You're not going to ramble.
I'm not rambling, sir.
Yes, you are.
Sir?
You are rambling. Now, I have stated a fact. There is an allegation here. A ticket has been issued. You either have to admit it or deny it. If you deny it, the matter will go to trial.
So, does the court have to have jurisdiction in this matter?
The court does have jurisdiction.
And, sir, is there evidence that the court has jurisdiction?
Yes.
What is that evidence, sir?
The Wisconsin state statutes, which adopted from the state constitution, which is adopted from the land ordinances of the Northwest Territory, which created the territory of Wisconsin, which was acknowledged, and Wisconsin was admitted to statehood in 1848 under the auspices of the United States Constitution, which was entered on September 17th, 1786, which adopted from the Declaration of Independence, which was on July 4th, 1776. I have read all of your briefs, sir, and I have researched them all. And that's the status of the law to which you are subject to as a resident of the state of Wisconsin, which you have acknowledged in your briefs.
Let me just write that down a second. You're saying that I acknowledge
you can order a transcript of what I have said.
Sir, I don't want to proceed if I'm not clear on what you're saying. I'm just seeking clarification.
You are going to proceed. I'm going to proceed today.
I'm seeking clarification of what you're saying. Are you saying that it is your opinion? Is that an arbitrary opinion that the state?
Absolutely not, sir. My opinion is based on the laws of the state of Wisconsin.
And what facts, sir? What facts and evidence do you have? What facts who has the burden of proof? Does the prosecutor have the burden of proof here today?
Burden of proof for what, sir? I have jurisdiction. I have stated that I have jurisdiction. If you don't want that jurisdiction, you may sit moot. You may challenge the jurisdiction. I have made the ruling. I have jurisdiction. Now, you want to proceed?
Yeah, I think we need to take a break here. We might have lost Gary. He's kind of grayed out on my screen. Gary, are you there? Okay.
Oh, that's weird. I see him. He's clear. He's not grayed out on my screen.
Okay. Are you still there, Gary?
That's odd.
Well, something might have happened. It happens.
What I think what happened there was he went on way too long with that speech and piled up so much shit. But by the time I tried to make a response, the last thing he said was something about me being a resident and that I had acknowledged I was a resident in my briefs. And it was I think I let him go on too long because it was difficult to get on track after that big long speech, and it was, as Fabrice said on the chat, it's nothing but opinions. And
whatever is coming out from his mouth is lies. So.
Can you back the microphone up a little bit from your mouth, and it won't pick up the interference like that, Camille?
Yeah, you're overmodulating. You're distorting.
Yeah, I'll put it a little bit down.
Yeah, you just have to back it off your face a little bit. Much better, thanks.
Hey, Paul, you should have said, objection, you, sir, are rambling on.
Yeah. Well, I wanted to, that's why I wanted to stop here. I wanted to get some suggestions from you guys for people who listen to this. How could I have interrupted that speech more effectively?
For me, Paul, I think you're doing great there, because as soon as he stops rambling, you're just kind of asking for a yes or no. You're just saying, have you got facts to substantiate your legal opinion? You know, if he's going to go on and make a great big speech about how the state does this and how the state does that, and how the state has had a history of 1,000 years worth of dishing out justice in the most beautiful way. That's great. Have you got the facts to substantiate that?
Fabrice, you're making a good point, Fabrice, but I that's what I failed to do. I didn't hold him to a yes or no response to basically any of my questions.
Exactly.
Yeah,
I have a
Go ahead, Joe.
I have a little tactic here that I think will not only address this one particular instance, but more effectively will address future instances, because if you handle this first one correctly, the judge will likely back off if he knows, oh shit, right? So, excuse me. So if the judge is, if he's going off on a big long ramble, what you need to do is remember the original question you asked. Now, when he gets done, you kind of have to let him go off. You just have to. When he gets done, the second he does, your first sentence is, so is that a yes or a no? Now, hopefully, he won't even remember the original question. And if he doesn't, great, because he's going to look dumb. He's not even going to know what he was answering in the first place. And so then you could, well, the question was this, and I'm looking for a yes or a no. Nothing more complicated than that. And if you do it super calm and like, you know, the whole little super respectful game and getting it on the transcript right, then hopefully he'll realize that, oh, if this guy asks a question, my tactics of diverting him and distracting him with other questions isn't going to work, because he's going to look at that piece of paper or whatever, focus on the question he just asked, and make sure he gets a yes or a no.
You're going super simple, Joe.
Lawful adversarial system type behavior.
It's super simple, because when you bounce them back straight to the question, they've got nowhere to go. You know, they can waffle and they can make it sound good, they can stand on a soapbox. Bottom line is, if you keep them to the question, they've got nowhere to go.
Yeah. Hey, Gary, we know you dropped there for a while, and what we just got done listening to was the judge's long speech about the history of the Constitution and all that. That was supposed to be facts proving that that the laws and statutes of the state of Wisconsin apply to me, and Joe pointed out that you just didn't come out and say, was that a yes or a no, and Fabrice said the same thing. So
and that's usually part of even when I'm role playing. I said, I'll just give a big old 5-minute speech about the duly formed court, blah blah blah. And it sounds like that's exactly what he did.
And then he ended by asserting that I had claimed I was a resident in my briefs. So let's listen to how I respond to that, his assertion that I said I was a resident.
It's distraction.
Do you have any facts and evidence to back that up besides just your opinion, sir?
I have the state constitution of Wisconsin.
And what facts associate me with the state constitution? When and where and why did it become applicable to me, sir?
You're a resident of the state of Wisconsin. You acknowledge that in your...
Go ahead, Gary.
No, it's okay.
Okay, I thought you wanted to pause.
Writings.
Sir, I made no such acknowledgement.
Yes, you did. We're going to proceed. Sir. I'm not going to sit here and argue with you, sir.
So at that point, I could have, maybe I should have tried to pin him down and say,
again, you're arguing. Objection, point of clarification. See, he's getting you to frame your clarifications as arguments, and he's wedging the notion that you're arguing into this, and he got you to. So I didn't claim that. He managed to say something absurd, and that got you into fight mode.
Can I have a quick go, Gary?
Please.
An argument is trying to convince somebody of another position. I'm not trying to convince anybody of any position. I am merely seeking to clarify.
Except that the judge managed to get him to say, I didn't put that in the brief. Even though what the judge had asserted was clearly and patently false. That's a good strategy from his perspective. It is not uncommon for them to come up with something absurd and proclaim it in order to get you to argue, and then for him to back up just like he did and say, I'm not going to argue with you.
Right.
And so, the right thing to do would be to say, I don't have any recollection of that. Could you point me to what you're referring to? It's clarifying, not arguing, not taking not the counter assertion, not the counter positive, but rather inquiring, investigation hat. You took it off there, and he got you to take it off, and he used it. He had you lined up that direction.
So just to be clear, okay, if I'm arguing with you, I am attempting to convince you of my position. If I'm asking for clarification, I'm attempting to understand what your perception is.
Correct, and why you have that position, or if it's arbitrary. But the judge just came out and said, in your position, you claim to be a resident. Now, true or false, it doesn't matter. He managed to goad you into a counter assertion instead of investigation. Mm-hmm. And that's not uncommon. We've heard it several times before. They'll just say something patently false. They might say, no, you don't have the right to be informed of the cause and nature of the truth, or whatever. They'll pick something to get you into argument mode.
The sky is purple.
You're fine.
Yeah.
Sky is purple. It's like, okay, hold on to that thought, and we'll come back to that when I see that it's relevant. But for the moment, my question was this.
Oh.
We'll get into residency in a moment in its application, But it's like, okay, so the notion of residency is something that you're giving the prosecutor because you believe that I told you that I was a resident. So let's look at where that paperwork is, because I have no recollection of bringing up an issue of residency, and I suspect that either somebody put something in on my pretending to be me, maybe, or something like that. So let's look at what you're referring to.
Okay, so I guess it's in a funny way, it's the same thing as what they're saying in Pavla's case, is she has a Czech driving license, so you can assert anything from there.
But again, the license again is a term of volunteering in. It's not a license anymore if somebody has a gun to your head.
Yeah.
So really, when you use that word, I don't even like using the word license, because
so before you get to license,
Sorry.
I was going to say, so before you get to license, you have to work out what that permission is for, what that license is for.
Right. Is it that I was given two choices, something that's called a license but doesn't really have anything to do with a voluntary acceptance of an obligation in return for a privilege? That's the crux of it. Is they're trying to call it a license when that's not it at all. It's a blackmail, a bribe. I mean, whatever. A payoff, I guess, for not being brutalized.
Yeah.
But a license would mean that you're asking for an exchange. That's not an exchange. A licenses in driving terms have nothing to do with involuntary interactions or exchanges. But they're making us use those words, and then they come back and everybody's, people tell me all the time, it's like, oh, the words are just the formal words. It's not that important. But then they come back at an issue like this where they do make an issue of it. It's like, well, you said you had a license. We're calling it a license. It's a different definition than the one that they have in their mind, which is you agreed to their bullshit in exchange for their privileges.
But they can't define any difference than if the guys came over outside your shop waving their baseball bats, threatening to smash in your windows and say, have you got a license to operate on our turf at this time of night?
Right. If all they mean by a license is a card that means that they're less likely to brutalize you, that's all it means. Let's be clear that it doesn't mean anything but a card that makes them less likely to brutalize me. And then they're cut off from the rest of their conversation, which is you agreed, because that's the next thing out of their mouth is, well, you agreed to blah blah blah. It's like, no, because you're switching back and forth between definitions of license.
And back that up with ethics if they need any more PR. Yeah, cool. Thanks, Gary.
Okay, here we go.
I have stated the facts.
I'm not arguing, sir.
Yes, you are.
I'm simply asking you to present the facts and evidence that your codes and statutes apply to me. When and where and how did they become applicable to me, sir?
Are you a resident of the state of Wisconsin?
I'm not here to answer. I'm not here to defend myself and answer your questions. You have to present evidence of that, sir.
No, I don't, sir. No, I do not.
So let me write that down. You don't have to present evidence.
He's absolutely right.
Yeah.
Why do you think
Let's push pause.
Job is supposed to be you?
Yeah, I messed that up. Definitely.
Okay.
And
he goes into it. I mean, he was controlling this conversation very clearly, right? Which
Right.
I understand completely. Again, I sympathize, I empathize.
Yeah, I mean, I should have said it that I somehow well, help me out then. How could I have responded more effectively to his?
What is the first thing that should be out of your mouth?
Some point of clarification.
4 words. Thank you. Objection. Point of clarification. What you just said was blah blah blah. How does that permit for blah blah blah? Or how is that justice? Or whatever. Instead of trying to go where he's trying to lead you, you back him up to the failure he just did.
That's so key. Instead of going where he's trying to lead you.
Right.
Okay, so that sounds like a bit to me like out Nazi the Nazi. You know, if somebody, you know, puts a line in the sand and say you're either for us or you're against us.
Right.
Then I guess what you say is, hey, I got this soapbox, I'm going to jump on it, and I'm going to use my voice and use what I can to the biggest of my attention. You're either saying I shoot myself in the left foot, or you shoot me in the right foot, and that's all I've got.
Right, and we're just clarifying. It's like, so there is no choice here by which I'm left in peace and not shot at all. You're telling me you're going to shoot me here or there. And again, the judge is prosecuting big time, right? And he's getting you off onto the topic he's wasting time on purpose, right? So that he can say we've wasted enough time, it's time to go on. And he can look good at doing it.
Yeah.
So let's just to summarize that response one more time. He makes the assertion that I'm a resident,
just to waste some time.
And right, but then I stumbled badly trying to instead of saying objection, point of clarification. So what's
the relevance of that title?
Okay.
Is what occurs to me is resident. What is resident and why does it matter?
No, how about this, Gary? What is resident without evidence?
Oh, sure. Yeah, what is resident and why does it matter? And what physically is it? I'm sorry, when I say is, I actually do mean physically.
Yeah.
What physical characteristics would be residence? What is it? A color? Is it a weight? It's just an opinion label that you're applying to me or saying I applied to myself.
Yeah, or what does that mean?
How do you know I meant what you intended?
When you say resident.
What's that?
What does that mean when you say resident? Okay,
right.
If I'm resident in Worthing, does that mean I agree to the body politic of Worthing?
Oh, I bet they would go ahead and go with that conclusion, yes. Because they get you to say, yes, I'm a resident or citizen or something, and then use that to their meaning. They expand the meaning to be their bitch, their subjugated, subject. Because they're just trying to find an synonym for subject that you'll agree to. Resident, citizen, defendant. All of these are fine. And as soon as you agree to any one of them, they're good to go.
Mm-hmm.
Yeah. But, if resident, I reside, I hung out in this particular patch of dirt.
But they do have one of the definitions of it is subjugated, and they'll start leveraging that. You see.
Okay, now just because I've had a couple of beers and I subjugated. What do you mean by subjugated? Is that like?
Does the word subject mean? Over there, the word subject would be meaningful, right?
Object.
Okay. Yes. You are subject, and when you are subjugated, you are put underneath somebody or under somebody's rule.
Enslaved.
It's a synonym for civilized, enslaved, indebted.
They're
bitch.
Subjugated.
My favorite word. In the morbid way,
Okay, let's pick up.
Just by saying, hey, I'm resident, I hang out here, Does
You're
that mean you're
confessing to being their bitch.
Right. Got it.
And that's what he was going for.
Yeah, he had me messed up. This was not a shining moment, but there's some good things we can learn here. So let's keep going.
It's very, very good example of very common tactics they use to get you off balance. You're fighting against someone who knew what they were doing. It's not that this guy was stumbling. He knew how to lead this conversation.
For sure. In his head, when he says resident, is he even thinking like 14th or 5th Amendments or anything like that?
No, he's not concerned. He knows that once he gets that on the record as you agree that you're resident, he's good to go.
So that's as far as it goes in his thought process.
It's closed.
It's her. Okay.
It's closed. He knows that that's all he needs. He needs something that where you indicated your desire to be subjugated.
Gotcha.
Right.
Not that agreements were
And in England, here with barons and counties, lords, the whole thing is that head trick.
Okay. All right. Let's go. Thanks for clarifying that. Let's pick it up the next thing here.
I have to present evidence that I have jurisdiction. I have jurisdiction because I am an elected judge by the people of the state of Wisconsin.
Okay. And what facts and evidence apply that to me? It's a non sequitur.
Sir, you don't understand. You're not an attorney. You don't understand. I suggest you get an attorney. I strongly suggest.
If I got an attorney, would you do what the attorney said? If I hired an attorney, would you do what that person said?
I would listen to the attorney, but the attorney would not be trying to make the arguments you are.
Sir, I'm asking clarifying questions.
Got distracted again.
What's that, Joe? Go ahead.
Well, I was just going to say, you just asked for the key question, where's the evidence? And then he asked you about getting an attorney, and you let yourself get distracted again. Just follow down that rabbit hole.
He picked a good topic, to distract you with.
Yeah.
Just one notch down, but it was not as good as the topic you chose, but he just dangled a slightly lesser one in your face in order to get you off topic.
Yep.
Right. Yep. I got it. Okay, let's pick it up.
Yeah, hang on a minute. Just one thing. Sure. In England here, I've come across a few people who've hired lawyers, solicitors to argue their case, and they catch up with me because they think their lawyer, their solicitor's not paying them enough attention, is not taking them seriously. And so I give them a few questions about jurisdiction, about evidence of complaining party, and when they ask that of the solicitor, that often gives us leverage to go into a higher court and say, we got one of your bar association guys, and they couldn't answer these questions. I'm here in court representing myself because your bar association guy couldn't answer these questions.
Yeah, it's very difficult to...
Can you answer these questions?
Yeah, it's very difficult to sever a representative and a determiner from a counsel. And over here, you've got to really know your stuff in order to keep those two straight and be very certain and very clear about what you're employing them for, and to limit them to not representing you or not speaking on your behalf.
Uh-huh.
Because immediately they'll sabotage you, generally speaking. They'll just do horrible, horrible things to waive tons of procedural stuff that would otherwise come to your help.
Okay. Another day, Gary. I'm going to get back to you on that, if that's all right.
Yeah, it's very interesting. I agree with you. I mean, I agree with the potential of it, but it's something you got to be really careful about. It's like hiring a saboteur,
Well, I had a guy who was. It was drugs. It wasn't an insignificant amount, and he asked questions of his lawyers. They weren't able to come up with it. We were able to put it in Crown. It got him some leverage, just for damage control. So it'd be interesting.
Because here, once you have a lawyer, they can pretty much shut you up entirely until sentencing.
Wow. Okay.
It's very difficult to. Yeah, I don't know. Maybe there's maybe there's some things we're not doing right, but
welcome to our world.
Conversation.
Maybe there's some differences in the system, but another day.
Okay, that's that.
Evidence that
I don't have to provide you with any evidence other than the fact that I am an elected judge in the state of Wisconsin, subject to the laws of the state of Wisconsin. You have acknowledged that you are a resident of the state of Wisconsin. You have
See, he's there. He goes. He's hanging his hat on that.
Yeah, and he says he doesn't have to provide any evidence, and he's correct.
No,
the prosecutor has to provide the evidence.
He's saying you acknowledge that you're a resident. He's basically saying you basically he's saying you forfeit you forfeit any challenge. See, he's trying to put into your mouth that you forfeit any challenge to jurisdiction. So that's really what you're needing to attack at this point.
Yeah, I was stumbling there. He had me.
He had you because right, wrong, or indifferent. He can move on with a lie. It doesn't actually hurt him to come up with that lie and go with it, because if he then gets you to move on, the lie was good enough to get you to move on. It doesn't matter that it wasn't true.
Doesn't matter that it didn't. That his claim of residency didn't prove anything.
It didn't matter. If you pled, if you move on to trial, it doesn't matter that there was a small error. Doesn't matter because you moved on. You obviously wanted to move on. And you could have corrected the error. He was telling you what you said. Why couldn't you correct the error? Fear. I mean, you and I understand that. It's you know that he's a dangerous human being, and you wouldn't put up with that over a fireside chat over coffee. But in a transcript, he just got done saying, "I read that you said you're a resident. You confessed the fundamental element of the ordeal, right?"
Yep.
And that's why I was so.
He just got done saying, "You yourself confessed it."
Yep.
That's why I was completely flummoxed, because I didn't confess it, and when I tried to protest earlier, he said I was arguing, and I was just at a loss for how to respond.
We're arguing. Okay, again, assertion, counter assertion, and investigation. He made the assertion that you had confessed. You, in turn, made the assertion that you had not confessed. That is an issue to go to trial. Instead, the approach has to be point of clarification. I'm trying to figure out if you're if you're thinking I filed something that said this, because I have no record of having filed anything in relation to residency. And I'm concerned that someone else filed it in, pretending to be me. So could you please point out what you're referring to when you say, I said that I'm a resident, so that I can clarify the misdeed, mistake, malice, lie, whatever it be.
Okay, got it. Okay, that's what I
And you'll still need to file something along those lines. You'll need to go through the documentation that you have and go to clarify that this judge asserted that you had confessed residency in one of your filings, and that you don't have any access to the information he's talking about, and that you definitely need a copy of this filing so that you can prosecute whoever put it in or whatever.
That's a very good point. That's a very good point.
You have everything you need.
You
have everything you need is kind of something that kind of comes back. And sometimes you have to say, no, I don't have everything I need.
Yeah. Now, I've actually had an opponent hire a lawyer pretending to be me in order to sabotage something. So it's not at all unusual, I've had it done. So it can happen. So why presume that he's not telling the truth? He might absolutely be looking at something that was submitted to him that says, I'm a resident, I'm wasting your time, whatever the hell.
Yeah, no, I'm not a resident. Okay?
Well, that's
and then after you get like 5 minutes waffle back, you have to say, I'm sorry, do you not understand the meaning of the word no?
But you see, he's saying that he's already got your confession of residency. And to say, I'm not, you can say, well, if you have anything that you think says I've claimed residency, I can clarify that to not meaning what you think it means.
He's trying to box Paul in, isn't he?
Right.
When he's doing that, he said, I've got your residency, I've got this. So
Yeah.
now I'm moving on.
And
I'm putting the pressure on you to say no. Don't you understand the meaning of the word no?
And he could later on come back and file a little note into there saying, oh, he was his memory was mistaken. The day before trial, he could file a little note that you never even really noticed that said, oh, I was mistaken. I was thinking of somebody else's case, but no harm, no foul, because he could correct it if he wanted to.
Yeah.
Right? I mean, there's nothing stopping that.
I
He can
think to
beat you down
rewind.
and then come back and correct himself in a breath of on page 6, a retraction. Kind of like they do with newspapers, where it's like you have a retraction back in the back page.
Yeah, for a front page headline.
Front page headline. It can totally happen. And I think I've seen that too, where I think it was in James's stuff, where they go on and yank them around, and then later on have something minor where it was like, oh, this was incorrect. It wasn't that.
Yeah. Yeah, and I think that's the part. If when they say, "Are you a resident?" you can just go, "No." That's something that Helen does really well.
But
she
the
just
fact
says
is,
no.
he asked that question. Yes, no, I'm sorry, I didn't mean to jump on you there. So sorry. But the fact that he asked the question is interesting. See, he went to say, you said you're a resident. Are you a resident? Well, sir, if you already proclaimed to have my answer, why are you asking me? So you confess that you don't know whether I think I'm a resident or not. Would you please tell me what you mean by the word?
Yes.
That was gold. That's going on the highlight reel.
Because you've got to leverage out when he says, well, are you? Are you a resident?
Yeah, but
Well,
do you understand the meaning of the word no?
I'm not here to testify. And it's like, well, I'm not here to confess essential elements of the prosecutor's case, damn it.
But what you and I are both here for, Gary, what Joe is here for, what Paul is here for, is to learn how to say no.
Right.
And do you understand the meaning of the word no?
Well, but
if you think I'm a resident, if you think I'm a citizen, if you think I'm subject to, I've got to say no.
I see that's awfully close to counter assertion, and that's a good way to end up in trial. No, I'm not a resident is exactly the wrong answer, because he's trying to get you to argue, because argument goes to trial. The fact that you're there arguing with the judge means you want to go.
I haven't seen the evidence.
Huh?
Why am I not a resident? Because I haven't seen the evidence.
Exactly. No, but no evidence has been presented. That's the rest of the sentence.
Oh yeah.
Are you a resident? I have not seen evidence on that issue. How about this? Here's one I've used a lot of times. Are you asking me for a legal determination?
The word no, it goes no evidence.
Yeah, no evidence. Are you asking me for a legal determination? Is a great answer or a great clarification to when someone asks you, are you a resident? Are you a citizen? Do you have a license? Are you asking me to make a legal determination?
Nice. That is a sharp arrow in the
yes. You say, okay, would you like to present your evidence?
Oh, damn. That's a good gotcha.
Ask you to be judge.
Hey, remember my last case, Gary, where the loud music thing, where it actually that's what got me off the hook, because I brought it up that there was no evidence that this house is mine, that I'm responsible for it, and that's exactly what the judge agreed with and dismissed the case. They didn't have any evidence of my residency here.
Yeah, that's a slightly different topic.
I know,
but
close.
Coming back at a question about legalities. Thank you very much. Coming back at a question about legalities, if someone asks you a legal question, he's asking you for a legal opinion. He's wanting you to give the legal opinion he wants, because he knows you'll be pressured to say, "Oh, I'm a resident," or "I'm a citizen," or whatever. But if you turn it around, he did in fact ask you for a legal determination. He didn't ask you a factual piece of information. Excellent. I'll give you my ruling tomorrow.
Yeah. Okay, let's pick it up.
The fact that you have a driver's license in the state of Wisconsin, you are subject to those laws. End of discussion. Now we're going to proceed.
Sir, excuse me, sir. I got a driver's license because I was under.
You have a driver's license for the state of Wisconsin?
I got a driver's license because I'm under threat, duress, and coercion. If I don't get a license, then someone's going to pull me over and harass me.
No,
I didn't get a license because I wanted to.
Driving is a privilege, sir. It's not a right.
Now, on that point,
Okay.
I didn't know what to say
You
there.
didn't know where to go.
Yeah. What's
Do you
that?
know where to go now?
What objection? Point of clarification. What evidence do you have that driving is a privilege?
No.
In fact,
What do you mean by it's a privilege? Again, what do you mean by driving? I'm talking about the fact that if I don't have a driver's license, people will brutalize me. And you're ignoring that topic in order to talk about driving as a privilege. Not you, him, you know.
Uh-huh. Yeah, I'm still not clear on how I could have responded there. Can you, Gary or Saul help us out? I mean, I don't get it.
Certainly. Okay, so their position is that driving, whatever that's defined as, is a privilege. And that's true. Except for one thing. The fact that people brutalize. People brutalize people who don't have the privilege. And who go about their
Okay,
normal life.
so like it's a privilege for me to travel, across the English Channel to another place. There, if I don't have this piece of paper that they call a passport, they might throw me in a rape cage for a couple of weeks and nick my stuff.
Well, they're dodging the issue. The issue is you got the license to avoid being brutalized, not to enjoy a privilege. They're trying to
The issue
reframe it
is,
as
if I don't get this piece of paper, I'm gonna have a hard time going to catch my family.
not just a hard time, but rather you're going to have people impose themselves violently upon you,
Yeah.
right? And that
Yeah.
goes beyond just somebody not giving you a lollipop.
Okay, that's
We're not
very
talking about
hard.
privileges at all. And they're trying to ignore the violence and talk about the privilege. You've got to talk about the violence.
Yeah.
It's funny for me to listen to Fabrizio, his angle coming from outside America, because it seems to me, let me just suggest that us in America, we're just so used to more aggressive judges. Like you're throwing out suggestions that are like totally right and make common sense if the other person gave a shit about manners and decency and civility, but they don't. And so part of the mastery that we're here to learn is also in what way can we word our contempt and clarifications in a legalese way that will not allow the judge to be able to go, you're arguing, we're moving on. You're in contempt, I'm moving on. I don't care. It's an art to the word choice. And here it's because they're so aggressive. That's why it's another level. That's all I'm saying.
So less aggressively would be the point that is it not for the prosecutor to prove beyond a reasonable doubt that I have a license in order to get a privilege rather than just to avoid violence?
I mean, yeah, that's perfect if you want to be less aggressive. I don't care if he's super aggressive. I'm just saying our judges are more aggressive than English judges.
I don't know.
Yeah, it could be.
I think they're just a little less, they're just as cold. They're just a little less voicey.
Let's see how nice they are when you start pushing number 2 to the limit. I bet the niceties go away.
Okay. Well, let's pick it up. So I tried to say that I got a license from under threat, duress, and coercion. Let's see what he said. What happens?
It's a privilege, and you have subjected yourself to the laws of the state of Wisconsin traffic laws. Now we're going to proceed.
Sir, I have many motions on the table. We're not ready to proceed, sir. I have motions on.
So I gave up on that point. I had nothing. I couldn't. I just, like I said, I wasn't prepared.
So you abandoned a critical point
right.
that he was asserting that you were guilty or at least not innocent, and you abandoned it. So you basically.
Yeah, I was feeling the heat.
You basically gave in.
I had abandoned the fact that I was a resident. I had abandoned the fact that I had a license, and so I was.
But that abandons your whole challenge, does it not?
I agree. I'm telling you, it was like I said, it wasn't a great hearing on my part. I don't know. I blew it, but I think that the reason I wanted to do this was because it's a good example of how a person can try to be ready and go in there and completely fall down, you know. So let's proceed and see what happens here. But yeah, I agree. It was bad.
We are ready to proceed. Don't you tell me, sir, that I am not ready to proceed. I am ready to proceed.
Does it matter if I'm ready to proceed, sir?
Yes. Yes, it does, because you were notified today.
Awesome. Now he said yes it does, and then he's gonna start steamrolling you in the very next sentence, right?
Right.
We're here, 10:30. We're here. You were notified. You are ready to proceed. If you're not ready to proceed, we're still going to proceed.
Sir, what are we proceeding with?
I'm proceeding with a try. I asked you if you wish to withdraw your not guilty plea. You have failed to answer me. Therefore, I am conducting a trial.
I did not.
Be quiet.
Sir,
Be quiet. We are proceeding to trial.
Sir, is it safe for me to
Would you be quiet? We are now proceeding to trial.
I object, sir. I'm not ready
I
to
don't
proceed.
care if you object or not. It's overruled. Mrs. Kershak, there are motions on the table.
So I just don't know how I could have handled that better right there. But any
Now you notice he went back to the motions on the table though. He was just bitch slapping you.
Yeah.
But he did go back to the motions.
Me personally, I think he was a bit scared. Just saying.
Right. But again, the decisiveness was missing, of course. But
the decisiveness on my objection?
On your part. No, on what you were doing. You know, you were like, is it safe for me to clarify?
You were thinking about the other guy.
Sir? Objection point of clarification would have been awesome in that point.
Yep.
It was just a shouting match, though. You know, I couldn't.
But objection point of clarification would have cut down all that shouting match.
Okay.
Because you're again, he's trying to make it look like you're arguing with him. All you're needing to do is clarify his statements and get at the details of what he has said. Yeah. Not bringing up any new topics, the same old topics he just said.
Got it.
Well, you need to be like a classy bitch and just say, hang on a minute, I got a question. It's this.
Yeah.
One thing I want to mention here too real quick, Paul, is this bantering that the judge is doing, like, you know, slapping you around like this. This kind of goes to what I said earlier about, you know, this kind of behavior from a judge, if you can kind of confidently address it from the get-go in a way that makes it very clear to him that you are not going to be distracted by his BS and will focus on the issues and the clarifications, it kind of lets him know, oh, that doesn't work. And then you get less of this in the future. And so it's kind of like if you take care of this one domino, a lot of dominoes get knocked out. You don't have to worry about.
Just like with a kid that learns that they get their way with a tantrum, will start getting more and more tantrums.
Exactly.
You catch tantrum A number one.
Sorry.
I was going to say, you catch tantrum A number one. You know, you make them look silly. One retort, be really assertive about it. They're not going to play that anymore.
And anything you're bringing up needs to be, okay, we can discuss that in a minute, but I actually really need to resolve the question I had about what you just said.
Yep.
We can then topic, I'll resolve that in a minute, but I really need to resolve what you said a moment ago.
That's really good.
Yeah.
You know, me personally,
all these topics.
And if you can,
topic. And when you were on a great topic, he'd suggest a decent topic. Like when you were on, do you have any evidence? He'd suggest, you know, a different topic of like citizenship and driver's license and stuff like that. You know, he'd dangle a good topic in front of you, and you'd go that way.
Yep. He did that with the driver's license thing. You were just ready to say, oh, I know stuff about driver's license and how I'm just dodging it because they're brutalizing me, so I'm going to get that cool line out on the record. And he tempted you with it, and you bit, and it was just a distraction.
How
Yeah,
about
and it could have been handled by, we'll get into the violent scenarios of the driver's license in a moment, but I need to clarify the question I just had first.
Sweet.
We had about 5 minutes with Helen where the guy went through driver's license, passport, voter registration, insurance. You know, how many different ways can you try and say, well, you know, you really agreed to abide by this code and statute?
Mm-hmm.
And all Helen did was say, no, show me the evidence.
And that's why I know I've harped on it a few times, and probably this is repeating things for several here. Getting them to state the case rather than getting them to say, I have a million reasons in my bag of why I have jurisdiction. Getting them to state their case before you start knocking them down is rather important, I think. It's like, okay, so you're saying that you have jurisdiction solely because of your election? Is that the end of your case? Is you have jurisdiction because of the election? Mm-hmm. And is that the only reason you have jurisdiction? You're resting your case, you know, you've stated your case with, I have jurisdiction because of this, and there's no other reason. So that when you knock that down, he's left without a case. Not, oh, well, I have a million more reasons in my bag. The driver's license, the passport, you know, the residence.
So if they get you onto the driver's license,
he's got a million reasons.
So if they get you onto the driver's license, Gary, and you say, you know, this is coercion. If I don't get a driving license, you'll come and smash in my windows, kick in my doors, and nick my car.
But first and foremost is get that as a stated case. So you're saying you have jurisdiction because of the driver's license.
And then
is that the assertion of the prosecutor? Is that the sole and only reason for jurisdiction is because of the driver's license? Oh no, and the election. Okay, so the election, the driver's license. What else, sir? What else is voter registration? Okay, what else, sir? Let's go through this list of things. All of the things, yeah. Let's list them all out so that we can, so that I'm not attacking things for the rest of eternity. Because I could attack a million things and he could pull something else out. Yeah. Oh, the Magna Carta. Oh, your mom signed this when you were born. Oh, he could come up with a million more.
Uh-huh. And the bottom line is after they've gone through all of those, is to remember the question that you came in on.
The clarification.
Mm-hmm. Right.
But see, there's a cost to this too, because if you just let him go through this, yeah, you may be right, but guess what he now succeeded in doing? He now succeeded in waiting 20 minutes of the court's time. And it was on an issue that you didn't really want to go down. And now he can say, oh, well, you wasted so much time, and I'm going to push this time.
That's the case. Well, thank you for clarifying the prosecution's case. Why wasn't it was like, well, wait, I don't remember this being in any of the paperwork. Where did the prosecutor state this? Or are you stating the prosecutor's case now?
To try and derail him from wasting 15 minutes off something.
But you're missing the main point that I just made. I'm sorry, and sorry to belabor it. The prosecutor didn't state these things. The judge did. And now after I've got a couple things listed, I'm like, wait a minute. I don't remember all this being stated in the prosecutor's case. Did he give you a secret stating of the case that you're reading from?
Yeah.
Or are you stating his case?
Yeah, I don't see it in the pleadings at all, Judge.
Right.
Where is it?
Are you making these pleadings, or is the prosecutor? Are you prosecuting me at the moment? You're stating the prosecution's case based upon what evidence?
Right. Who do you
supposing
represent?
that I have a driver's license or whatever. You know, well, in that case, not so much, but you know.
Okay, let's pick it up.
Motion to vacate a not guilty plea. That has been handled. Mr. Mozina, I'm going to find you in contempt of court. If you keep interrupting, now be quiet.
For me to speak.
Be quiet. There's a motion to vacate a not guilty plea. I have addressed that with.
Well, Joe, how would you have handled that?
Oh, don't know. I'm just giggling.
Damn it.
There you go.
What, Gary?
OPOC. Now, see, Joe, okay, I just want to bring a little topic here. Joe and I had a little debate about this a little while back, and he felt that this was a very good way to piss a judge off. And now you can see, Joe, why OPOC is so important. You have to object to every time they're done making a statement, whether it's the prosecutor or the judge. First thing out of your mouth is objection, point of clarification, so that you're not agreeing with everything. And stop from saying, okay, like you did a couple of times, Paul, and they were sarcastic okays, but when it's written in the transcript, it ain't sarcastic. It says, okay.
Yeah, good point. Okay, where I go again? Let's
Mr. Messina, he has indicated to me that he does not wish to proceed. That motion is denied.
I have to disagree with that, sir. I really.
We have a motion to strike or dismiss the citation. That is denied.
But on what grounds, sir? Is that the arbitrary opinion? Can you cite the legal grounds for which you made that denial, sir?
One question at a time.
Yeah.
I know. I just you're right. No doubt about it. And he completely ignored it and didn't answer any of my 3 questions.
Correct.
He only has to answer the last one.
he didn't answer any
He
of them.
doesn't even do that.
Or he doesn't even have to do that, yeah. He can only address the last one and then steamroll it.
Yeah. So I mean, I guess let's say I had only asked one question. Objection: is that an arbitrary opinion? And he had just
Objection, point of clarification is that arbitrary opinion.
and assume that he had just ignored me and continued on with his next statement.
Objection, sir. Are you going to answer my questions?
I need to know on what grounds that was denied so that I can correct whatever fringe issue you have or whatever nuance you have an issue with, so that I can get the fundamental issue I raise addressed, sincerely addressed, rather than you denying it over mundane details.
Right. Okay.
There's a motion to strike or dismiss the complaint for prosecutor misconduct. That is a matter that will be handled by the Board of Professional Responsibility. The court finds nothing in the record or in the indication from Mr. Mozina that there has been any prosecutional.
Wait, didn't your motion contain evidence of it?
Did my motion contain evidence of the prosecutor's misconduct? Yes, it did.
Okay, so his statement just there was false, correct?
Yes.
Hey, Gary.
So
Sorry,
maybe you'll
can I hold
want
you
to
for a
go
moment?
ahead and file that something had gone missing in the record and wasn't given to the judge, and that this needs to be corrected forthwith.
Okay, got it.
Because the judge said there was nothing in the record when you submitted it into the record, so something was removed from the record,
Yeah.
right?
Can I just catch you for one moment here, guys? Just so I can get up to speed. Where's this recording from?
Oh, you don't have it? You didn't hear it yet?
No, I don't have it. My computer went down a few days ago. I'm trying to get it repaired.
Oh man, it's clear. How did you make it clear, Paul? How'd you get that recording so clear?
It's from the court.
Oh, okay.
So where's this? Is this a recording of you in court, Paul?
Yeah. It's in the municipal court.
Holy shit!
Yeah, we're listening to a recording. That's what this entire group chat is about listening to this recording and then letting Gary tell us how to do it better. That's pretty much what this is.
Am I running roughshod over people? Sorry about that.
No, it's perfect.
Okay. I'd just like to say, for me, this is an education.
It is
Yeah,
for
that's
all
what we're
of us.
trying to get at.
Coming from England, this is an education.
Sweet.
And I'm
Listen up.
glad you guys are rough and tough and, charge on some more. Thanks.
Yeah, pull up an air.
Well, what just happened is that he said that he denied that my motion to dismiss for prosecutorial misconduct had any merit, and there were some good points in there. But he said it was going to be forwarded to the board for a professional.
No, but then he said that there wasn't anything.
Yeah, he said you could forward it to the board. He didn't say he's going to do it.
Oh, he said He said that they were going to do it. And
No, he said it in the abstract. This
That's
sort of
right.
thing's forwarded to the board.
Back it up. Listen to it clearly.
Okay, here we go. Let me back up a second.
That is a matter that would be handled by the Board of Professional Responsibility. The court finds nothing in the record or in the indication from Mr. Mozina.
Okay, yes, you're right. He said that is a matter that will be handled.
Yeah, and he said they find nothing in the record or from you to indicate.
So he ain't helping you.
So he just lied because you did provide this. You didn't leave it missing.
But I'm glad we reviewed this because I misinterpreted what he said. I thought that they were going to handle forwarding it.
Oh, they're brilliant at misleading, getting you to think what they want.
Okay, all right. Well, I was going to mention that in my request for clarification of the record.
But that doesn't mean. See, again, that's handled by them. That doesn't solve your problem.
Well, yeah.
You're saying, that kind of thing. We deal with that internally to correct our own problems. That doesn't. My issues here and now.
Right.
How it affects this case isn't an issue for the review board.
Right.
The review board has no jurisdiction over this case. And he went on to say, well, I find nothing in the record or blah, blah, blah. And you said, I agree, by saying nothing.
Right. Yeah.
Can I just check on...
Yes, point of clarification, did you not receive this motion, which has this page of things listed?
Yeah.
The fact that you disagree with them or you don't find them compelling or you have other information, that's a secondary thing. He said nothing was in there. Zero.
Right.
So can I just get some clarification here? Did you put in like a motion, Paul?
Yeah, I filed a motion to dismiss.
To dismiss the case. To question whether that evidence.
We would call it abuse process.
Hey, Fabrice, you're not familiar with this case at all, are you? This is like Paul's third visit in, Paul, or fourth?
Third, yeah.
Yeah, third. So I've been following this since the beginning. This is a good one.
Yeah. No, I'm afraid I haven't. I caught it, I think, after the first, and I haven't been up to speed.
If you want to ask questions about it, you can ask them in the chat box. I'll be more than happy to answer.
Thanks.
Okay. Yeah. So let's just proceed. But Gary, I got your point. Is that I failed to say that this is an issue right here and now, and that
he said that there is no evidence of prosecutorial misconduct in front of him.
And I didn't protest. Yeah, got it.
You didn't clarify. I'm sorry. Are you missing this page?
Right.
I have a date stamped, list of the things, the evidence itself, and you just proclaimed that you had nothing, zero. Not that you didn't like it. Not that you dismissed. That you felt it wasn't a problem. Again, then you'd start talking about his bias, right?
Right. Okay, gotcha. Here we go.
Okay.
Now, that there has been any prosecutional misconduct. So that is dismissed also. There is a motion to rescind Judge Hausman's orders. Judge Hausman's orders have no effect in this court, and they are not being considered, and that motion has no merits, and is that...
Wait. What did Judge Hausman do?
He ordered that the matter be set for trial.
Okay, but he's setting it for trial anyways himself, so he's saying that doesn't really matter because I'm doing it on my own. Did Hausman put in the plea?
No, the plea was in from the first judge. But so
did Hausman order you to appear?
No, I'm not sure what you mean by that. But go ahead. What do you mean?
Did he reschedule things and make you appear again? Show up again.
I had the first judge was substituted, and then I went and saw Judge Hausman, and he stomped on me immediately and denied everything and set the matter for trial. So
so he denied the same thing that this judge denied.
Right, but much more.
Okay, so this guy's right in that's fully redundant, right?
Well, wait a second. I mean, when you say that guy's right, I'm not sure what you mean.
That judge just said that he's dismissing. He's just dismissing your motion to to vacate all the other judge's orders because they're redundant anyways. They have no effect.
Not that they're redundant. The other judge ordered that the matter be set for trial, and my motion to rescind.
This judge just ordered it to be set for trial anyways, so that makes that redundant.
No, he didn't. He didn't get there yet. He didn't order it to set for trial yet. He's still going through the motions. And the point, and what I was trying to say is, I filed a motion to rescind Judge Housen's orders, and then I reviewed the language, and I thought a motion to vacate the judgment and expunge him from the record would be better. A motion to vacate his orders. So I filed a second motion to vacate his orders, and I cited a court case that the prosecutor had actually given me that indicated that if a judge is disqualified, all of his orders are void. So my point was that the Judge Houseman's orders that the matter be set for trial were void, and Judge Cook just confessed that. He said, "Yeah, everything Judge Houseman said is
that's
moot."
fine, but he's making it a moot issue because he's about to do everything anyways.
Right, but then one of my motions for clarification of the record is, Judge Cook, where is Judge Cook's order that the matter be set for trial? He said Judge Houseman's orders are void. So it
doesn't matter. See, he can set it for trial himself, which he's probably going to do, right?
Well, but the thing is, though, am I not entitled to notice an opportunity to respond to this judge setting the matter for trial?
It becomes moot if he's about to set it for trial, or does he just proceed right on into trial?
He just proceeds right into trial. So and he never, and so there's no order from Judge Cook setting the matter for trial, and that's one of my clarifications of the record. Go ahead, Judge. Go ahead, Judge.
Great.
If you're trying to get clarified, hey, I'm trying to get my stay of execution from a judge who's about to order your execution, do you see why he would say this doesn't make any sense? I don't have to pay attention to it. Moving on. I mean, you could be right, but what's effective?
Well, again, but the point is that this is in fact a procedural due process violation. He had no notice. He had no notice of trial except for a void one.
Right, and he also goes on to deny the discovery request that was granted by the first judge. So he changed the rules of the game and said, "We're going to trial right now, and here's my rules."
But that's okay. So. There's a procedural problem here in that you had no notice of trial.
Exactly.
Except for a void one. So that's a motion in itself right now.
Well, that's what I filed it with.
Let me ask you this: where's your next? I'm real curious now. What's your next level to go to appeal this?
Well, no, not appeal.
Oh no, he's going. He hasn't been through trial yet. He hasn't been through trial yet. I got you. He's just been arraigned. Huh? No,
hang on.
He went right into trial.
They went right into trial, but let me just answer Tom's question. Tom, I'm filing a motion, or not a motion, a request for clarification of the record with the Chief Judge of the Municipal District, and this is one of the issues I'm raising, is that Judge Cook said that Judge Houseman's rules were meaningless and had no effect in this court. He just vacated Judge Houseman's order that the matter be set for trial. Then, without setting the matter for trial, he initiated the trial. He proceeded to trial, and just to make sure that he knew it was his rules, he denied a discovery motion that had been granted by the first judge 6 months earlier, when I didn't even have that motion on the table. So now I'm going to go ahead.
You didn't have that motion on the table again this time? You just assumed that you were going to. I'm just asking. I'm not being a smartass.
Tom, I had the motion on the table to rescind Judge Houseman's orders, and I had a second motion to vacate them. I had two versions of the motion, and by his language, he actually implicitly, his language was explicit. He granted my motion to vacate Judge Houseman's orders and expunge them from the record, because he said Judge Houseman's orders have no effect in this courtroom, and that's why the motion to rescind has no merit, because I've already vacated everything that guy said. That's why he used that language when he denied my motion to rescind the order.
Wow,
because he had already vacated that judge's orders. and I was too slow to. You can see I missed so many things. I didn't pick up on it at the time.
So he started over. He just started completely over. That's why he was able to ignore all that, because
he just said, fuck it, I'm going ahead, and this is my court,
yep,
and I'm
my case now. Yep,
doing the trial right now, and you don't get discovery, and here we go.
Yep.
Execute you anyway.
But didn't it end? Am I dreaming, or did it end with you're going to a trial now coming up?
It's in 30 seconds here. The trial's going to start. Yes.
Yeah. Okay. Yep. With the cop. Yep. With the. Okay. Go ahead.
It's good stuff too. Here we go.
Okay.
Dismissed all.
Well, I should mention too that he didn't rule on my motion in limine, and I'm also pointing that out in my request for clarification of the record because according to their rules, they're supposed to keep a record of all motions and the rulings made on the motions, and there's no official documentation in the record of his ruling on my motion to vacate or ruling on my motion in limine. So it's procedural stuff, but I'm pulling out all the straws and gonna go. I'm going.
You got a chief judge. This is why I always ask what the structure is in where you're at, and what level you're at, because you're under one of the underlings. There's still one more step you can go to, so that's good.
Right. Well, yeah, but Tom, I'm not filing an appeal. I'm filing a request for clarification of the record.
Right. Okay. Let's see how that works.
Just from me here in the UK. The more you can catch of any kind of abusive process, any way in which the prosecutor isn't doing what they're supposed to do, any which way in which you go to 2 plea hearings and nothing happened, the more ways in which you can lay that out, the better. Because they're far more likely to let you off the hook for an abusive process than they will do for saying that they haven't got the evidence.
Got it, Fabrice. Thank you. I'm definitely pursuing that angle. Okay, let's
Way to follow up on him, Paul. Way to follow up on him and make him answer. That's all. Keep going.
Yeah, I think the trial's going to start here.
Okay. We are now going to proceed on the trial for speeding.
Do I have the right to plead guilty here today, sir?
Huh?
Do I have the right to plead guilty
Yes,
here
you
today,
do.
sir? Do I still have the right to plead
Yes, you
guilty?
do. Do you wish to plead
Do
guilty?
Yes. Do I have the right to make an informed plea of guilty here today, sir?
A what?
An informed plea of guilty here today, sir? Do I have the right to make an informed plea of guilty here today, sir?
Yes. Go ahead. I'll accept your guilty plea.
Do I have the right to be informed of the nature and cause of the proceedings here today, sir?
You have that. You have the ticket.
Hey, Paul, can I hold on for 1 second? What I like that as a classic example is where you were right on track and you said, you should have said, would you be able to take an uninformed plea of guilty? If I wasn't informed and I didn't really understand, would you be able to accept that plea, your judge?
Good one.
And that's what you...
Yeah, but he's doing great. I mean,
Yeah,
but the judge is
he's
trying
getting
to be
on a roll
dismissive.
now. I agree, yep. Go ahead,
The
Paul.
judge is trying to say, well, you've been informed, as we always do when we're role-playing, exactly that line.
And I will accept your guilty plea.
Yeah,
Because that's what you just suggested.
Yep, true.
Okay, let's see what he says.
Go ahead, yep.
The codes and statutes of the state of Wisconsin apply to me on this ticket, sir. I have a copy right here. Can you show me where on the ticket is there evidence that the codes and statutes of the state of Wisconsin apply?
It has your name. It has your address. It has the ordinance that was violated, 4201. It was delivered
That was violated?
It states...
That was violated.
Oh, okay, so he's assuming guilt there, isn't he?
Presumably.
I would bring that up as he'd already shown bias at this point, and that you didn't quite hear it at the time, but he'd already determined that you were guilty of violating it before the trial.
Shazam.
Nix it all on that. Shazam. That's huge.
Right there.
That's brilliant. Okay, I will
He
do
shot
that.
himself in the foot by saying that you are guilty.
You violated. Past tense.
Not accused of violating. There's no qualifier there whatsoever going on.
Right. Excellent.
He
Okay.
It's like pointing out the obvious.
And I would make that into a big old motion right there.
Well, I do just for everyone's information. I've studied the statutes a little bit, and I'm going to file a motion for relief from judgment. Okay.
Well, and it's not, and the judge, and I'd point out that judgment had been made before the trial began, as confessed by the judge at minute whatever, blah 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 of
right.
the recording.
Well, absolutely. I'm glad you pointed it out because that's what why I wanted to get you all together here to
Miss that.
Yes, I did miss that.
It's easy to go over for that.
I would not have recognized that was a critical confession by the judge of his bias, and now I will be including that. Okay, so let's proceed. I don't know how far I got with this protest here before the trial starts. I think let's just hear it.
Specifically, that you were exceeding the speed limit of 16 to 19 miles per over by going 49 in a 30, which is 19 miles over the limit. That is in.
Sir, you're reciting what's on the allegation, sir. I'm asking if there's facts and evidence.
We would do that, sir, in trial.
That proves. Sir, I'm challenging the court's jurisdiction.
You don't have any right to challenge the court's jurisdiction.
Wait.
I have stated, sir.
Excuse me, sir. I don't have a right to challenge the court's jurisdiction.
Be quiet.
Let me write that down. I don't have a right to challenge the court's jurisdiction.
Excuse me, sir.
Well, you're right, Tom. I should point of clarification would have been more.
It'll make him stop. You turned it into a rambling argument. He was right. I can't believe he didn't throw you in jail, man. I've been in front of some of these guys. They wouldn't put up with that shit.
Okay.
Anyway, go ahead.
I have ruled this court has jurisdiction. That matter is now closed.
And what facts and evidence did you bring to prove that, sir?
You wish to proceed? Please call your first witness.
He's taking your silence as a yes there.
Yeah, I was reeling.
Once you cross that line of proceed, you're kind of fucked. It's another stage.
Well, I like I said, it wasn't a shining. I'm a little.
I still have the right to plead guilty here today.
Yeah.
Why did I just lose the right to plead guilty?
Yep, right there. That's the question.
Good point, Gary. Yep.
That's exactly what you should have just. Yep. The same thing I just said, but that's exactly the line you should have fed that back with. But you're right now getting on a roll. Like you can tell you were getting your feet to get your footing. You know,
well,
you've been in there
really,
enough
Tom,
now.
I kind of bailed out on there, and he proceeded to start the trial. So again, it was
that's what they wanted to do.
Yeah, it was. I'm telling you, it was really frustrating. I prepared a lot, and I just it didn't go well. But I think there's some good things for other people to learn from it. So that's why we're going through it here. So.
But you did in fact get them to make mistakes.
Well, we hope so, and it's up to me now to get some clarifying questions out there. And
the judge said you had violated it before the trial. That's pretty critical.
Yeah. Right on, Gary. I really appreciate you pointing that out because I did not pick that up. Okay,
he's saying you can win the whole thing on that alone.
That
you
alone.
Give that weight to it. He wants you to feel the weight of that.
Right.
Yes. Everything else is. Minor in comparison to that statement.
Right, but so the point though, the challenge for me though is to get someone to evaluate that statement that is in a position to do something about it.
Well,
so I don't know if that's
motion to void, motion to vacate everything he said.
Okay,
because of his proclamation of bias.
Okay, but now who's going to hear the motion?
There you go. That's what I keep saying, and it's going to be the chief judge in his court. I'm telling you right now.
Okay, how's the chief judge going to go saying that's okay for him to say?
Wait a second, guys. I don't know if I can do this or not. Are you suggesting that I can file a motion to vacate with the chief judge of the district court?
You're telling me that the trial just happened, and if I recall right, he fined you at the end of this thing, and that was the end of it. So now the only alternative you have...
You know it.
What?
We've had this discussion many times, and it's bullshit.
No, I understand. I'm just saying, at this point, it's considered to be over in their eyes.
By who? By you?
No. In their eyes. In their eyes,
Whose
right?
eyes?
Just stop for a second, Gary. Serious. The court just made a decision, and Paul walked out, and it's
Bullshit.
supposed to be over. No. Okay.
No, that's my point.
Is there another date?
You can't ignore what I said and keep re-saying what you said.
Just simple. Is there another date scheduled, Paul?
Gary, stop.
Is there another date scheduled, Paul?
No, there's not another date scheduled, and this is the crux of the issue here is I agree that Gary's got a great point there, and my challenge is who do I present that motion to vacate to?
Well,
that
you already have a mechanism. You yourself brought up the mechanism.
Okay.
What do they call it? A block judgment or
to relieve
request of judgment?
Okay, Gary, that's all right. That's what I was going to do. I was going to include it in the request for relief from judgment, which their statutes say you can bring up, and with the current, court or whatever venue that you're in. So I'll include this in that.
And include the confession that the judge made that he'd already judged the case before that,
right,
before the trial.
I will. I guess you said file a motion to vacate, and I was just trying to clarify what that was about, and we're in agreement. Yes.
Same thing, different name.
And to file it with whom now? Who's he filing it with?
Well, Tom, I looked at the statutes, Tom, and I put it on the anti-arraignment role play chat. The court citations, they have the Wisconsin statutes support something called a request for relief. It's it's just called relief from judgment. It's a request for relief from judgment.
Right.
So,
and who's it go to?
It goes to the current venue, whoever the judge presiding over the current case, so
it's designed to do exactly what we've been talking about all this time. And I bet your court has the same thing.
That's
if
exactly
something
right.
Can't be appealed because it wasn't justice to begin with, I bet there's a procedure for you too.
Tom, I suggest, go back to the anti-arraignment role play. I posted it around 2 o'clock today on the anti-arraignment group chat. The whole explanation of it is right there. So just take a peek at it. But it appears that using their rules, I can get this in front of them. And in fact, it says that when they get a request for relief from judgment, they have to notify all parties and schedule a motion hearing for it.
Who is they? The clerk?
The clerk has to schedule a motion hearing for it.
I'm asking, you're going to file it with the clerk, right? That's they who you're speaking of, correct?
Yes, sir. I'm going to file it with the venue in which this last proceeding occurred. I'm going to file it with that clerk, and I will have a cover letter that points out to the clerk that their statutes dictate that when they get a motion like this, they have to notify all the parties and schedule it for a motion hearing. So I expect that I will get another day in court before the same judge.
And I would have several pages of the history of judges confessing to have prejudged the case. On a federal level, on a local level, I would make that the end-all be-all.
Okay, so find some citations of existing court cases where the judge prejudged the case, and that was the reason why it was thrown out.
Revealed a bias. Revealed that he'd already made a determination before the trial.
Okay, I got to do some research.
Or anything came up where,
That's happened in almost every case I've ever been in. The judge says, "Well, you were speeding, mister." That's it. He's already. That's why I've said, "Are you on his side?" You were speeding, mister.
And you do it all the time in the role play. It just blows me away that.
Go ahead, Gary.
It just blows me away that these judges already before the trial say you violated blah blah blah.
Yeah.
Right.
Not that you're
the prosecutor. They're the
Okay.
prosecutor. They're all three. The prosecutor's lips hardly ever move.
Right. See,
Right.
and that's the truth, because the prosecutor says you violated it, and then they get promoted to judge, and they don't drop that bad habit, so they don't count.
Let's
Right?
let's put one more thing down here. So I have a
Good to know
challenge.
the
Hang on, Joe. I have a challenge now to find some court cases that I can cite that will demonstrate how this type of behavior. Yes. Yeah. So can you suggest a way to research? How do I go about? Where do I research existing?
I don't know. Any cases where I don't know. And it doesn't even. I mean, yeah, cases in that jurisdictional, tower would be best. But anywhere where it's discussed the injustice when a judge reveals that he's already judged the case, the injustice of that judge proceeding to hold the trial.
I got you. I'm just saying that there are thousands and millions of cases that have occurred, and I just was wondering if there was a tool or interface that was.
Yeah.
Okay.
Google's the only one I can think of.
Oh no, there's a. Have you ever seen the course Juris Dictionary? Once you take that course, brother, you learn a lot. My friend and I, Kurt, took it.
Okay, all right.
But that doesn't help him find cases that he's
Yes,
talking
it does.
about.
The guy totally explains. It's not on the top of my head right now. I haven't used it, but totally explains of different. It costs a little bit of money, but you can research law libraries like you fucking wouldn't believe, man, just for a few bucks.
Okay.
I can speak to this a little bit because I spent time doing it before I found Mark's site. I like the setup questions that some people have suggested, saying, does this court, what in so many words, obey the Supreme Court rulings, and what happens if the judge doesn't, and blah, 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 so that if you do want to use something like that, Supreme Court cases are great. How I find the easiest way to find something specific on information was just by using Google, man. The Supreme Court cases, there's something called U.S. Supreme Court reports, and I don't know how high up on the chain that is or if it matters, but you'll easily find a Supreme Court case relating to what phrase was it that Gary used? Predetermined something or other that the judge had made he had admitted basically or whatnot, that you had violated something in the past, and so there was no presumption of innocence. I mean, anything along those lines, you'll be amazed at how easily you'll see something come up.
Okay.
Is my point.
I'll do it.
Yeah.
All right. So go ahead, Fabrice.
I was just going to say we have this similar thing in England. We've got a chunk of shepherdizing, exactly. You can grab little bits here and there, but the bottom line is actually you just find cases where judges have been prejudicial, and it as long as you can show that that has precedent.
Yeah, and you quote judges
Then
talking
actually
badly
you just
about
run
that
from there.
injustice. Oh, sorry.
Okay.
Yeah, and you quote other judges talking how badly how unjust that is. So you have a bunch of quotes from judges talking about the injustice of prejudged lawyers.
Uh-huh.
Yeah, you gotta have
It's
that
not
ready.
that you're relying on a precedent. You're relying on the fundamental notion of injustice of a judge who basically said that you violated it, that you're guilty, going on to the case.
Okay. All right. Let's pick it up again. Thank you for that. Huh.
Sir, do I have a chance? I would like the chance to vote during the witness, please, sir.
You will, sir. We're conducting a trial. Be quiet.
I would like to vote during the witness before to establish the competency of the witness. I would like to vote during the witness before he begins his testimony. Otherwise, we can't know if this person is competent to testify on the matters before the court today, sir.
You are. Your request is denied, sir.
On what grounds, sir? On what grounds is my do I not have a right to check the competency of this witness? This is the state's witness against me, sir.
You will have the right in cross-examination, sir.
Before this person's testimony.
That's not relevant, damn it. He's saying you have the right to something else. Voir dire.
About these matters, sir?
No.
Okay, let me write that down. I don't have the right to inquire into the competency of the deputy.
Sir, please. I want to tell you something. If you keep interrupting the court, I am going to hold you in contempt. You can write down anything you want. I am on the record. The record will be provided to you. I don't care what you write down. I really don't care what you write down, sir. It's of no consequence whatsoever to me. It's not in evidence. And you want to enter it later.
Well, he's upset because the whole point to writing it down is to repeat it. You know what I mean?
Yeah.
To make it more clear on the record. And he's upset by that, so he's kind of lashing out to keep you from doing it, right?
Uh-huh. And I did
because it was effective. He hates it because it's effective.
Yeah.
Right. Okay.
Enter your evidence. You may do so. Please proceed.
Oh, by the way, that should be part of your motion. That you were overtly and brazenly denied any right to voir dire the witness.
Gary, I looked at the statutes and I don't see anything supporting my assertion.
Why do you think statutes are relevant?
Okay,
Just
good
because the
point.
statute doesn't enshrine a due process, do you
Okay.
think that due process goes away?
Good point, man. That's why
That's an issue of substantive due process, not procedural.
Okay, good
Yeah,
point.
that's a good example of it. Good one, Gary.
That all witnesses should be vetted for having relevant and firsthand testimony.
Excellent. Well, thank you for bringing that up. I was going to let it slide because I was locked into the mindset of if it's not in the statutes, I can't invoke it. But I appreciate that.
They ignore substantive due process. It's all about procedural for them. But procedure is supposed to support and encourage substantive, and to be subjected to a witness before going the road. Examining the relevance of it. But go ahead.
Okay.
And we've been beating you up about this, Paul. But,
remember Mark's? Sorry.
No, go ahead.
You remember Mark's point of just calling a random witness out of the galley? No.
Well,
Suddenly he'll remember how to void your witness.
Well, yeah, you'll see me try to do that later, and it's kind of. I actually do try to do that, Gary, and you'll have a good laugh when you hear me do it. Okay, let's. Joe, did you want to say something too?
I was just going to say, we're beating you up, but you deserve props for kind of sticking to that don't I get to voir dire so that you have something to bring up, something so strong to bring up in your later motions in the first place. It was because you knew to do that and you kind of stuck to it. That's all. I was just saying, good job on that.
Well, thanks, man. Some good and a lot of F-ups there too. Go ahead, Fabrice.
I was just going to say, there's a lot there that actually you stick your backbone in there and give it hell yeah, and hopefully, I don't know enough about the American system, but hopefully there's enough there that you can leverage that later on.
Right on, man. Okay, let's. This next part's gonna be pretty boring. But you're gonna hear me try to catch the cop making a legal determination. And the first time that I object, I effed up.
Objection calls for a legal conclusion. Or
yes, I did. No, I did. I said that, but I said it at the wrong time. The second time I get it, but the first one was a miscue. But so let's listen to her with the witness here.
And how are you employed?
As a patrol officer with the Waukesha County Sheriff's Department.
Sir, speak up, please, and speak into the microphone.
How long have you been employed in that capacity?
It'll be about 2.5 years.
Were you on a duty as a Waukesha County Sheriff's Deputy on January 16th of this year?
Yes, I was.
Do you recall the hours of your shift that day?
Yes, I do. It was from 2:45 to 11 p.m.
What were the nature of your duties during your shift that day?
I was on patrol and just looking for traffic violations.
In your employment with the Waukesha County Sheriff Deputy's Office, do you have a specific role that relates to the town of Lisbon?
Yes, I do. I'm the contract deputy for the town of Lisbon.
Can you explain what that means exactly?
Every day I work for the town of Lisbon in that area of the town of Lisbon.
Do you recall where you were located at approximately 6:48 p.m. on January 16th of 2015?
Yes, I do. I was up on County Line Road near Collier Road.
Is that location within the limits of the town of Lisbon?
Yes, it is.
While in that location at that time, did you observe the defendant operate a motor vehicle?
Yes, I did.
Where was the defendant when you first saw him?
He was on County Line Road traveling eastbound.
And where were you located when you first saw the defendant?
I was also on County Line Road. I was running stationary.
And what, if anything, drew your attention to the defendant's vehicle?
I noticed that he was traveling at a high rate of speed.
And was that based on your own observation or based on a reading from the radar?
On my own observations, and then when I turned on my radar, it validated my observations.
Objection calls for a legal conclusion.
Overruled.
I'll look around, sir.
Overruled.
Do you test that radar machine before using it?
Yes, I do.
How often do you do that?
Before I go out on patrol, and then after every stop.
How do you test the machine?
There's an internal test and then an external test with the tuning forks.
Can you explain briefly how you test it with the tuning forks?
We have 2 different tuning forks. You hit it, it makes a tone. You put it in front of the radar, and each tuning fork has different speeds that it should be at.
And did you test the radar machine that you were using that day prior to your shift?
Yes, I did.
And did you all test it again prior to the stop of the defendant in this case?
Yes, I did.
Was the machine working properly during those tests?
Yes, it was.
Did you test the machine again after your encounter with this defendant?
Yes, I did.
And was it working properly then?
Yes, it was.
You said that the radar confirmed your suspicion that the defendant was traveling at a high rate of speed. What did the radar tell you?
It clocked him at 49 miles an hour in a 30-mile-an-hour zone.
Is the 30-mile-an-hour limit posted in that particular area?
Yes, it is.
Do you know where it is posted in relation to where you and the defendant were located?
It would have been...
Can we pause for a moment? Just to get clear kind of what's going awry here overall?
Yes.
Okay. So he's going on and on about the details of presuming the law is applicable. And the proper objection is relevance on these points because it presumes facts, not an evidence, about the foundation of it, which is the applicability of the code. They're trying to build things from the top down. You know, and instead of establishing a foundation, they're trying to say in what manner you violated the law, leaving off the applicability of the law. And they'll say, if you ask, they'll say they'll come back around to it or something probably, but they're not even bothering. So objection foundation, you know, again, this is presuming applicability of this of the speed limit, right? And
good point, Gary. Thank you.
Relevance of the city. But I understand you wouldn't get very far, but just as a matter of procedure, I guess, you know, maybe saying objection, you know, relevance or objection foundation, you know, applicability of the law has not yet been determined. It presumes facts, not an evidence about the applicability of these statutes.
Can you please elaborate on the use of the word foundation? I've never heard that in conjunction with an objection before.
Oh, objection foundation? Okay, that's an objection. Okay, so when someone's building a case, they're supposed to start out with things that are obviously relevant and true to the accusation and build it from there, rather than telling you about details of what's going on, like this cop's doing. I was sitting here. I was on duty. I'd stuck a tuning fork up my butt. Whatever the hell he's talking about, right? But the foundation of it, you're sitting there wondering why this is relevant, right?
Mm-hmm.
Because they're building the case backwards. In order to...
I'll drop.
We lost Gary.
He's saying objection, relevance. Objection, relevance. Objection, relevance, basically.
Right, and he's explaining what the objection of a foundation, and I was trying to follow what he was saying, and I was having a hard time, I confess.
I think he was saying that that they have to build a case, not state like silly, frivolous facts. I was sitting in my car. I know how to tune. You know this. I was watching for traffic,
Right.
and then I pulled this over. I mean, these are things that are like on a cop cam. Who cares? Nobody's disputing this.
Right, until you dispute it, that shouldn't even be brought up. Who gives a fuck what he was doing with his tuning fork?
They have to build a case. They have to actually
Right, exactly.
build one, prove it. This is about unless you're found guilty.
And you do know the elements of a case, right, Paul?
Yes.
Okay, and those, see, that's the thing. I like to look at the prosecutor. Quit looking at the judge and arguing with the judge. All these questions should be to the prosecutor. The judge is supposed to rule on them. That's it. So
Well,
I
if they
tended
let
to
you,
look to the
sometimes
left.
they don't.
I looked to the left, and it worked. It worked. It pisses the judge off. You don't ask him questions. You don't talk to him. Objection. I'm looking at the witness or the prosecutor, the plaintiff, and I'm waiting to see the evidence. And do you have it? I mean, just quit arguing with the judge. You're making it too easy for them to be the prosecutor.
Right. Okay, got it. Well, let's go ahead. Go ahead, John.
Well, I was just going to say, what I've done in mind, speaking to what Tom's talking about here, is it's almost like the prosecution was speaking, and then I would speak, and then the prosecution was speaking, and then I would speak, but we were both looking at the judge, and the judge let this go on. I'm just giving you an instance of success I recently had, so that, in essence, I could communicate with the prosecution and back and forth, and the judge allowed it, because like I said, sometimes they simply don't. And again, here's another tactic about trying to get the judge to stop playing Mr. Prosecutor or Mrs. Prosecutor, and if he asks any kind of discovery type questions that a prosecutor would, just bringing the fact that he shouldn't be doing that's the prosecutor's burden to do, can help instigate a conversation of words actually coming out of the prosecution's desk if that's your goal, because it's what's in your best interest for your case, sure.
And remember something else. Mark's thing, and Gary always emphasizes it, is our goal is not to try to piss the judge off, but to try to drive a wedge between him and the prosecutor, make him not be on the prosecutor's side, make him question the prosecutor.
That's true, but if you listen to the whole audio, the judge was the prosecutor.
Oh, yeah.
And maybe he should have just said, "Excuse me, sir, are you the prosecutor? Because you're sounding like one. I mean, are you being biased, or what's wrong with you, sir?" Or something like that,
That's my point
From
about
where I
directing.
come from, Paul, it's the more you can make it so that the judge doesn't want to be in that spot. The judge doesn't want to play the prosecutor. Make it so that it's really uncomfortable for the judge to sit there and answer those prosecutor questions, and then hopefully he'll bounce them across to the prosecutor.
That's the
if you do that once, I guess it's a little bit like Joe from Hawaii was saying. If you do that once, you hold them down to it once, then they won't walk all over you.
Right.
Well,
Okay.
assuming they don't steamroll you, yeah.
Okay, looks like Gary joined the call. We tried to carry on without you, Gary, but
yeah, I got cut off mid rant, huh?
Well, you were just, if you want to just finish your thought about what a foundational objection, foundational grounds for.
It's basically you're saying objection lacking foundation. Like they didn't build their foundation first before introducing this, so that the relevance of it is unclear. It's similar to relevance, objection relevance, or presumes facts not in evidence. They're all related.
What is the foundation that what conceivably could they have presented as the foundation?
I don't know. That's for them to figure out. But they're going on introducing evidence about where this guy stuck a tuning fork or whatever the hell. I mean, again, they're getting to it, but the right way around would be ignoring the lack of foundation up to that point, but saying, the speed gun said that he was traveling at blah blah blah, and the reason I know that to be accurate is blah blah blah. You go the other way around, not and the reason I was there was because I was employed, and the reason I've been the other way around. They want to approach the whole case backwards, going from your guilt forwards, instead of from the foundation to your guilt.
Okay.
Why? Because they never actually get to the foundation. They have to.
Like, let's start with the elements of the case. That's kind of what I brought up when you faded out.
Applicability of the law. That's the big step that they always skip. The applicability. That's the foundation.
Okay.
If they addressed it, what would it sound like if you were the prosecutor?
He signed this letter of enlistment and swore to abide by the military codes, and we're prosecuting him under this military code. You mean a conceivably a malum prohibitum that is involuntary? No such thing.
Yeah, I gotcha. I just want to make sure it was that far.
huge secret, is malum prohibitum that was never agreed to.
Okay.
Of consent.
Got it. Excellent.
Oh, sorry.
I was just speaking German just for,
But what's that?
Right, 1, 2, 3, suffer. 1, 2, 3, suffer. If they can flirt on you, if they can catch you out, if they can freak you out, just for a moment, just for a second, and then get you to pay for it, job done.
And they investigate on how best to do that by probing you expertly, skillfully learned over decades sometimes on where you're weak, and where they find out, this guy's weak in this area, then they'll push in that area. If they're having success and they can get you further down the trail, that's exactly what they're doing. Their tactics might be completely different for one dude to the other, just because they have this chameleon-like ability to find out where you're weak and attack. It's manipulative bullshit, obviously, part of the game.
Okay, so how about bouncing it? How about bouncing it back? If you have the same chameleon-like ability to answer a question, like Gary Capps does, to clarify, to elucidate, to actually see if there is anything there at all.
That's called a cap slap. It exists. It happens.
Yeah, well, a cap slap. That's what I got to do when I check that I don't have, property of Her Majesty's government stamped on my forehead anywhere that I wasn't looking for.
Where's your barcode?
Did I sign up? Did I sign up for something? Did I blanked out on?
We assigned it to you.
Okay. Well, at least confess that. If they would say this is being imposed upon you with no regard to agreement or justice or anything, at least confess that. But they gotta dodge that issue. They get all shifty around it.
Yeah. Excellent.
And if they say, we're not concerned with ethics on this issue, we are imposing this upon you. Great. Thank you very much for your confession. I'm going to back out of this place.
Right.
Yeah.
Well, thanks for drilling into that point. That was very helpful. Let's pick it up here.
How did you know that the radar was giving you a valid reading?
Gave me a clear, audible tone with no interference.
If there had been interference, what would it sound like?
The tone would have been choppy.
Do you have any reason to believe there was any other vehicle in the radar's beam when you received the reading of 49 miles per hour?
No, the defendant was the only vehicle on the road at the time.
Based on your observation, what did you do?
After he...
What was that, Gary?
It's clearly not true. In his view, it was the only vehicle, but not on the road.
Okay.
He's exaggerating,
From where I was sitting on the side of the road, I then conducted a traffic stop.
Objection. Calls for legal conclusions.
Wait, what was the legal
The
conclusion?
officer can testify.
Okay, let me rewind it a few seconds here.
Conducted a traffic stop.
Hang on.
There was any other vehicle in the radar's beam when you received the reading of 49 miles per hour?
No, the defendant was the only vehicle on the road at the time.
Based on your observation, what did you do?
After he passed me from where I was sitting on the side of the road, I then conducted a traffic stop.
Objection. Calls for legal conclusions.
Wait. Conducted a traffic stop. Calls for legal conclusion? Help me understand what you mean.
Go ahead, Gary. What was that?
Help me understand what you mean by that calls for a legal conclusion.
Well, he had decided that I had violated the law and he needed to stop me. So therefore,
No. He testified that he did something called conducting a traffic stop.
Okay.
And you called that a legal conclusion. What do you mean? So without going beyond what he just said.
Well, you got me there, Gary.
I know what you mean, Paul. He's thinking that the guy has to make a legal determination to pull him over.
I agree. The problem is that he objected to a specific sentence not overall.
Right.
He objected to, I conducted a traffic stop. Objection, that calls for a legal conclusion. How does that call for a legal conclusion?
Okay.
He's describing an action that he did. Now, I agree that the underpinnings of that call for a legal conclusion. Because a traffic stop, as we know, is pulling somebody over for a violation.
Right. A reason.
Right? So, I mean, I was hoping you'd go there. I mean, I wasn't saying you were wrong. I was saying you need to be able to argue it. Conducting a traffic stop presumes applicability of the law.
Right. Okay.
That is why it calls for a legal conclusion.
Right, and I don't think I defended it. He just said denied, and I didn't have a good comeback.
No, that's perfect though. You see, objection denied is perfect. Call for a legal conclusion. You're looking for them to deny it.
Well, you know what, though, Gary? He doesn't deny it. Listen to what he says. Here, let's let him play.
Officer can testify what he did.
The officer can testify what he did.
Correct. He was looking at the physical action that he just testified about.
Right. So that's why. So he didn't deny it. He didn't deny my objection. He just said, "Well,
I know, because it's you see the problem is it's too abstract. The legal conclusion in what just happened is too abstract, and the judge kind of leveraged that to get out of it. And he's kind of right in a wrong sense. You know what I mean?
Let's rewind it a couple seconds. Let's just let that roll through.
No. Yeah, let it roll.
Do you have any reason to believe there was any other vehicle in the radar's beam when you received the reading of 49 miles per hour?
No, the defendant was the only vehicle on the road at the time.
Based on your observation, what did you do?
After he passed me from where I was sitting on the side of the road, I then conducted a traffic stop.
Objection. Calls for legal conclusions.
Well, the officer can testify what he did.
See, so the conducted a traffic stop is a purely physical thing, right?
Yeah.
According to the judge.
Yeah.
It's an event. He can testify to what he did. Okay. We'll move on.
Decide that
It's not a legal conclusion. It's an issue of fact, sir. He stopped you.
Okay, let me. I said something after that. Just give me a second here.
Conducted a traffic stop.
Objection. Calls for legal conclusions.
Well, the officer can testify what he did.
It calls for legal conclusion. He decided that
It's not a legal conclusion. It's an issue of fact, sir. He stopped you. He got a reading.
Based on what grounds, sir?
He got a reading.
Based on his legal conclusions, sir?
No, not on a fact. A legal fact. Overruled.
A legal fact? The fuck
I
is a
can
legal
clear
fact?
this up. I can clear this up. The judge said, the cop said a statement with two parts to it. He said, I pulled him over, and then I pulled over to the side of the road or stopped him. And what I think Paul heard was, he heard, I pulled him over for a reason, and then he missed the part of, and then I pulled over on the side of the road. And so what's happening is Paul is arguing, hey, his reason is illegit, where the judge is saying, no, he just pulled over on the side of the road, and that's the one you're talking about. Yeah, so the judge, like you said, do you get that, Paul? I'm trying to see if Paul is getting that.
I'm not, but should we just rewind? Should we listen to it again?
No, don't rewind. No, don't rewind. We've heard it several times now. It's okay. But the two things are, he conducted a traffic stop. The physical thing versus the implication, the legal thing.
Yes.
And he's talking about a legal fact now. Okay? For instance, operating a motor vehicle describes a physical event in the manifest world and has a legal fact to it. This opinion-based garbage about being within subject, to statutes and so forth. And they're mixed, and judges don't like to see the difference because their job relies on mixing them. Now, you're talking about he pulled me over. Pulling somebody over is a legal activity. And the judge just confessed it by saying that's a legal fact. Whatever the fuck a legal fact is.
Yeah.
Objection. Gary said that he doesn't know what a legal fact is, so I know that that would work in court.
What is a legal fact? It's not a fact. It's certainly not anything that could be called a fact.
Okay. So
That's like an imaginary reality. That's nonsense.
He didn't actually say denied. He didn't actually say denied and affirm that the officer is qualified to make legal determinations.
No, but he said it wasn't a legal determination and made your whole objection moot, so it didn't need to be denied. It was denied by de facto.
Okay, what I'm getting at is I don't know if I properly set up the objection that when I ultimately asked the cop if he filed a valid cause of action and the prosecutor objects,
Correct.
that the judge sustains it. I didn't set the table with.
You need the judge to say that he can't make legal conclusions.
And I didn't get him to do that. I didn't get him to do that.
Yeah.
And I don't know how I could have gotten it out of him. You're going to hear me make the same objection a few more times, and he goes, "Sir, you don't know what you're doing." So it's a little embarrassing. But maybe let's proceed. We got still quite a ways to go here, so we'll have to go.
Deputy O'Toole, do you recall any description of the defendant's vehicle?
It was a black truck.
When you pulled out, did you activate your lights and sirens?
I first ran the defendant's plates, and then yes, I activated my lights.
Did the defendant pull over?
Yes, he did.
Did you make contact with the person who was operating?
Yes, I did.
And did you identify yourself to that person?
Yes, I did.
Did you tell the person why you stopped him or her?
Yes, I did.
What did you say?
Say that I'm Deputy O'Toole with the Waukesha Sheriff's Department. The reason I'm stopping you today is I clocked you at 49 miles an hour at 30 mile an hour zone.
Objection. Calls for legal conclusion.
Overruled. Statement of fact by the officer.
No.
Are you able to identify?
Calls for legal conclusion. Wait. So they just sidestepped. They're trying to pretend he's reciting this allegation now, right?
Mm-hmm.
But he's testifying that he said it. So he's reciting the actual events, which is a little sneaky.
Uh-oh.
Right?
Wow.
So is it factual if you're quoting yourself accusing somebody of a crime?
Yeah. Well, so the objection was timely there.
Well, kind of. Here's the problem. So he's testifying that he himself accused you of violating the law earlier. He's quoting himself accusing you of speeding.
Right.
So is he making that accusation, or is he just quoting himself making that accusation?
Wow. It sounds to me like he was making a legal conclusion.
Well, the problem is you got to clarify,
where that comes in.
But the judge will probably say that was he's just reciting what occurred.
Right.
Yeah, the legal conclusion would be separate from what he just said. Like Gary just said, he's just saying what he said in the complaint. The legal conclusion would be
he's saying what he said at the side of the road. Let's be clear.
Either way, but it's in the complaint, sort of. Now, if you want to argue the legal part of it,
he's not testifying about his complaint. He's testifying about the side of the road.
The cop is.
Yes.
And that's what he wrote. Well, okay, I see what you're saying. Going into
so
detail.
you're trying to object to him reciting the events, which is a little bit problematic. I get it, but okay.
But there is a legal conclusion.
But I understand
also.
your objection. I would have made it too. Just to be clear, it's like, well, just to be clear, he's quoting himself accusing me of being subject to the law.
There's the legal conclusion. He's quoting himself of making me subject to the law that he has made a legal determination over.
He's quoting himself making a legal determination. I agree that he's just stating a fact, but he's reciting the accusation, and I object to that being entered here.
I see how that could have been done better. Right on.
Yeah, it's weird. It's a good point, though. It brings up a very good point. I'll have to think about that one. Go ahead.
By the driver?
Yes, I did.
How did you do that?
The Wisconsin full driver's license.
And is the person that you identified as the operator of the vehicle that day present in the courtroom here today?
Yes, he is.
Where is he located?
Sitting to my right, a short sleeve t-shirt and a tie.
Will let the record reflect that the deputy has identified the defendant as the driver that day?
Sure.
I just want to make a point there. I was not wearing a t-shirt and a tie.
Okay.
Any objection?
Wait. Let me back that up a second, because they're playing the name game here.
Mozina, do you have any objection?
Okay, I'm sorry. I just want to capture this. Bear with me here.
Person that.
So he's trying to get you to object to the T-shirt thing.
No, I was making a dumb joke that the cop said I was wearing a T-shirt with a tie.
No. I just heard the judge say, "Do you have an objection?" or something like that.
Right. I'm replaying it here. I'm sorry. I just want you to hear this all the way through without interruption here.
Vehicle that day present in the courtroom here today?
Yes, he is.
Where is he located?
Sitting to my right in a short sleeve t-shirt and a tie.
Will let the record reflect that the deputy has identified the defendant as the driver that day?
Mr. Mozina, you have any objection?
I certainly do, sir. I have many questions for the deputy. May I proceed?
No? Mr. Mozina has...
What was that?
He asked you if you had objections, and you said no. You have some questions, but go ahead.
No, I messed up.
Yeah.
Let's do it here.
Well, no, he said no. I have many objections.
Indicate any objection to the officer identifying him. The record will so reflect that the officer has identified Paul J. Mozina as the individual that he stopped on the date and time in question.
Okay, this is the issue that Freeborn Angel keeps bringing up, that there's some magic about them associating you with the name and all this shit, and I...
Oh, of course. Fucking name game shit. Yes.
So can we put that here? I mean, what the hell's going on here then?
What, you want to run down of the name game?
Well, why are they doing this making such a big deal out of
because identity is important to them. Because identity is one of the things they have to establish in order to dot their I's and cross their T's. But it's not the name game. They only care about identifying you.
Okay.
And the fact that you're accused, and the fact that this is all one person being discussed is one of the factors that they're going to, rely on being proved. Now, and that's why they were like making damn sure that you had an opportunity to, raising objections, not that you were steamrolled on that point. Good God, he steamrolls you on every other objection you have.
Every other fucking thing.
Okay. All right. Here we go.
Proceed on.
Wait, could he not?
Go ahead, Sal.
Could he not? And I said, well, how did he? Oh, yeah. Well, he identified you because you gave him the license, right?
Right.
Okay, so then he could say, well, that's you, and that's.
For the clarification, what does identify mean?
Uh-oh, Steve.
Well, you're the individual, and you're the person, and you're not the man.
No, see, you're reading into it with things that they haven't even said yet. Don't go beyond, what is in front of you. Do you have any objections? Well, what does identify mean? Depends on what you mean by identify. But then again, you've not put, the prosecutor to task for clarifying anything so far. So.
Right.
So what if he did not produce the driver's license? What if he said, well, I don't have that, it's at home, or whatever?
Well, they would have identified him in another way, though.
Yes, I know,
but
again,
isn't that the way they identified him?
Yeah, but isn't that a way of saying, well, we identified him because he gave us positive identification versus us having to play around?
It doesn't matter. Identification is identification. Again, abstract person versus man, woman, whatever, that aside, we haven't even gotten to that question. They're still being vague enough to where it doesn't, I identified him by the driver's license or whatever. But, presumes facts not in evidence would have been the objection, I guess.
And the reason I bring that up is because the rule of law, Guyman always says never give him the driver's license, because then You have no way of proving you're a driver / identification.
Bullshit. Again, your side of the road, you're dealing with a guy with a gun. Don't forget that. And the idea that there's magic in denying them ceremonial shit about identity is a good way to get yourself hurt.
God, I'm so glad to hear somebody say this. It'll end so much wasted time in the chat room. Shit, you have no idea.
But now, keep in mind, I'm all for it. See, the name game is actually true in a sense. We're not persons. We're not legal fictions. That's just fundamentally true, though. It doesn't need to be played around with.
Yeah,
are you blah, blah, blah?
Are
Are you asking if I'm a legal fiction, or are you asking if I'm a
How about you throw a gun in the room, Gary?
Yeah. Are you Gary Capps? Well, I mean, I'm one of many Gary Cappses. I'm one of, there are tons of people and legal fictions and all kinds of shit that use that name. So you're going to have to be a little bit more clear. Put it back in there,
Yeah, well, I just let it go. So let's proceed here.
And again, you're presuming that, only you have that driver's license. How do you know there's not 18 Mexicans with that same driver's license? Do you know?
No.
How does he know?
Good point.
How does
It's
he
all
know
right.
that the information on the driver's license is accurate? He identified you with it. How does he know it's accurate?
So you've got to be effective with it. And see how he's being effective with it. If you can't be effective with it, that's what matters. I mean, so other people, they might be right, 100% right. But unless they can be effective with it, what good is it, I guess? So if you can be effective, cool, go for it.
I know.
Did the defendant make any statement to you during your initial contact?
Yes, he did.
What did he say?
He stated that speed limit signs are optional and that he committed no crime.
Wait.
Object.
He's quoting you literally?
Yeah, he is.
No. Is he paraphrasing what you said, or is he quoting what you said?
He's quoting. And
you
I
said
think
literally the phrase he just said to you.
that's what he says I said, and I objected and said I never said that.
Wait, no. Hold on.
Okay.
To be clear, because that's the important difference is in the details here.
Mm-hmm.
He said roughly a paraphrasing of what you said, or is he quoting what you said?
It sounds to me like he's quoting what I said.
It could be said he's summarizing what you said.
But that's a problem.
Mm-hmm.
Summarizing what somebody else said is saying things for them. You can say what you took from it, but to say what someone said precludes paraphrasing.
What's the name of that objection?
Ooh, good one.
Hearsay?
Well, you'd go back and clarify.
Objection.
Cross-exam, right?
You are embellishing what I said.
No. It's like, well, so you were when you said what I said, you were actually meaning to say what you'd taken away from it, not what I said. Just to be clear, because
Yeah, that's a good one.
the only manner in which it'd be true for you to say what I said is if you quoted me, is if you said literally what I had said, not paraphrasing, not putting it into your own words, because once you paraphrase and put it into your own words, you're saying what you understood my sentiment, and you nail them on it. But anyways, that's beside the point.
I see.
Well,
So objection, the witness is attempting to
No, you can't object
quote what I said.
because you go ahead and let him lay down his lie, and you go back and you correct it.
Oh, I see. Okay, I got it.
You correct
Yeah,
my
cross-examination.
I see. Okay. But when he went, you'll see in the future the cross-examination problem. Sorry, keep going. We'll get there.
I was just going to say, the Latin phrase is verbatim, word for word.
Yes.
When you quote somebody word for word, that's transcript territory. It either is or it isn't.
Yes. But if you say what they said and you summarize it or put your own spin on it or rephrase it, you're lying. If you say he said and you're not literally quoting him, you're lying. It's in fact a misleading, it's inaccurate.
I do it all the time.
Well, in court it's different though. If you're accusing somebody and trying to get them punished on that issue, it's different.
Yeah, for sure.
Okay.
But and to be more honest, you would say what I took you to say was blah blah blah. Just to avoid a straw man, so forth.
Yeah.
Okay.
And later on, I would go about saying, so you're just trying to put words into my mouth in order to prejudice this court against me. Is that correct?
Nice. That is good.
Something along those lines.
But wait for the cross-examination to do it.
Well, you can't object based upon a lie.
Okay, that's what I tried to do.
Is there anything where somebody, so that you can stop something with a perjury issue?
Or misrepresentation.
No. Well, a perjury issue. I mean, if somebody lies, if someone says something incorrect, how do you, I know in Britain there you have to pretty much grin and bear it. But
no, abusive process. Apparently that's what I'm good at.
What if you objected?
But there's no instant objection to a lie that just occurred, right?
What if he knew the lie that occurred and knew just by memory, big hypothetical, the writing in the books that he violated?
It was a perjury.
Well, like the intentional aspect of a lie.
Yeah, if somebody perjures themselves,
yeah.
In theory, shouldn't there be something stopping that right then and there so that you can go off on a tangent about the perjury and solve that matter before they're allowed to perjure themselves further?
Sounds like a clarification, but you can't use that at this point.
No,
is that right?
I did it. You heard it on the show. Mark played it my last court date where I was saying objection. Judge, what are you objecting to now? I said he's lying. I did. No, that's what I did though. I did it a couple of times. He says you can't make that objection. That's not an objection. I said, well, I object anyway. He's lying. I couldn't help it.
Objection, sir.
Style points count.
Yeah.
Opportunity to cross-examine the witness.
I'm going to have to follow that up some more. Thanks, guys.
Any response to his comment?
I just stated that the speed limits are not optional.
And what happened next?
At that time, that's when I got his driver's license and went back to my car.
And then what did you do?
I ran him through my in-squad computer and issued a citation.
Citation for?
For exceeding speed limits.
Now, objection.
Which I issued.
Well, he's still just reciting it.
That's the legal conclusion.
Overruled. Sir, you don't understand what a legal conclusion is. You may make those objections. They will be overruled because they have no basis. Proceed.
Well, I just want to pause it there. I mean, I think he's wrong. I did have
Again, he's quoting himself, right? He's quoting himself, accusing you. He's quoting himself, making a legal conclusion. So he's stating a fact of an event where he accused you,
and made
where he made a legal conclusion.
Right. So my objection is merited, and so the judge is just.
I understand, but the judge is playing games, and I get that
Right.
The problem again is that weird one where he is factually quoting himself accusing you and getting it into the record as such.
Yeah. Okay.
I think I've heard Mark say this before. How has he made a determination to pull me over if he didn't decide I broke some kind of law? Of course he made a legal determination. Well, you're not at the point yet
where you can.
Pardon me?
You see, you've got to get the objection called for a legal conclusion. You see, he's telling this in a narrative, which really kind of screws us up.
The cop, yeah.
Because he's not actually, he's narrating a past event where he accused you.
Yeah, so he'll have to wait for cross-examination, basically.
Well, but in cross-examination, you can't object on your own question, calling for a legal conclusion.
You can. I see what you're saying. Yeah, you can say, you can ask him if he can make.
No, you can't ask him for a legal conclusion and then object to it.
Wait a minute, Paul does corner him because he does use. If we go a little further here, he does catch him Let's keep listening.
Okay, go ahead.
Ask you what your decision to base the issuance of the ticket was on. Could
Whoa. Did she just ask the cop what he was basing his issuance of the ticket on?
Let's listen.
Yeah. See?
Sorry, I
There
think
it is.
what your decision to base the issuance of the ticket was on.
Officer has asked that.
Okay.
Oh, look at that. The judge actually kept him from doing the legal conclusion except in the narrative.
Right, because she actually made a mistake and asked him a straightforward question, which he would have had to answer in the present moment, saying I decided.
And you would have had he knew that you were already itching on the legal conclusion, but it's already been answered. Objection. He was telling a narrative, and this question now relates to the accusation.
Right.
But it's not already been answered, but it's also a problematic question.
Well, keep going, because it's going to get better. Because Paul's going to turn this around. I remember this coming. I thought this was a good one.
Give the citation to the defendant in person?
Yes, I did.
Did you make any additional statement to the defendant at the time?
Offending person calls for legal conclusion right there.
Okay. I could have got the prosecutor on making a legal conclusion.
No, she asked a question.
Oh, let's listen to it again. I missed it.
Asked that.
Okay. And did you then give the citation to the defendant in person?
Yes, I did.
Did you make any additional statement to the defendant at that time?
I just issued and explained the citation to him.
Did he make any comments to you?
He became very argumentative in stating that I didn't have jurisdiction over.
Well, we missed something there.
We wanted to back up.
Okay, sorry about that.
I'm sorry, I think I asked you what your decision to base the issuance of the ticket was on.
Officer has asked that.
Okay.
Yeah, answering for her. What was that?
Give the citation
For him to her.
person?
Yes, I did.
Did you make any additional statement to the defendant at that time?
I just issued and explained the citation to him.
Did he make any comments to you?
He became very argumentative in stating that I didn't have jurisdiction over him and wanted proof of that.
So how did you proceed from there?
Basically became into a verbal argument, which I stated that he would have his time in court to argue that fact. And that's what he took off.
After that, on the day of the stop, did you have any further contact with the defendant?
After the stop?
Correct.
No, I did not.
I have no further questions for this deputy at this time.
Thank you. Mr. Mozina, now is your turn not to testify. You will be given an opportunity to do that. You may now cross-examine the officer.
As if you're 5 years old.
Deputy O'Toole, did you get any special training to be a deputy?
Yes, I did.
What did that consist of?
Went to the police academy, and also when I got hired, I went through 20 weeks of field training.
Went through what, sir?
I went to the police academy.
And then what?
And when I got hired through the Waukesha County Sheriff's Department, I went through 20 weeks of field training.
Have you studied the Wisconsin traffic statutes?
Directly?
Just answer the question.
Yes.
Yes, you have. Okay. Have you studied the municipal ordinances of the town of Lisbon?
Yes, I have.
Do you make legal determinations when you apply the law?
Can you speak up, please?
Do you make legal determinations when you apply the law?
Objection, relevance.
Can the officer...
Can you repeat the question, please?
Do you make legal determinations when you apply the law?
Yes.
Okay. Are you an expert in the interpretation and application of the Wisconsin Constitution and state statutes?
An expert?
What's the relevancy, sir?
I'm inquiring about his capacity and competency to make legal determinations when he applies the law.
The judge just objected for the prosecution.
Yep, exactly.
Well, the judge asked about relevance, though.
Yeah.
Yeah.
Again, it's obvious, but he's asking about it.
Something he'll never do for Paul.
And the relevance, the relevance is that this cop has entered legal determinations into this court. That's the relevance.
And the best part is Paul's going to bust him in a few minutes because he just said the cop can make legal determinations, and in a few minutes he's going to say he can't. Watch. Keep going, Paul.
Wait, the judge said he could make legal determinations or couldn't?
Yeah, Joe was talking right when Paul turned the recording back on. The judge said she objected to him making the answer to that question, and the judge, right when Joe started talking, said he can answer that question.
Yeah,
That's not saying he can make legal determinations. That's saying he can answer the question.
That was the question Paul asked, wasn't it?
Yeah, but he said he can answer the question. He didn't say he can make legal determinations.
Paul asked him, "Did you make a legal determination to pull me over?" Basically.
Let's listen to it again.
Yeah.
Make legal determinations when you apply the law.
Yes.
See?
Are you an expert in the interpretation and application of the Wisconsin Constitution and state statutes?
An expert?
What's the relevancy, sir?
I'm inquiring about his capacity and competency to make legal determinations when he applies the law.
What does your question have to do with this speeding ticket?
You've got him, and he knows it.
Yep.
He tried to distract you right there.
Keep going.
I bet he's doing good. Let's see how he does.
Keep going.
Okay. Well, wait a second now, guys. We can let's listen to it again.
No!
We're listening.
We were winding again?
We were listening.
You were talking right over it.
Oh, sorry.
Legal determinations when he applies the law.
What does your question have to do with this speeding ticket?
He made a determination that the laws of the state of Wisconsin apply to me. And I'm going to be asking the deputy what facts and evidence does he have to back up his belief that the laws of the state of Wisconsin apply to me. So that's why I'm asking about his competency in that matter, sir.
Okay, the officer can answer that.
Bingo.
I've been trained to apply the law.
Good.
I don't.
Good. Now, why do you think that was a critical point there?
Because in my opinion,
Because the judge backed down because he knew he had nothing he could swat you down on. You actually clearly stated the reason that you were heading down this road.
Yeah.
Right.
Sweet.
Bonus
He was
points.
trying to get you to fumble so that he could say, piss off.
Okay.
Because it had worked in the past, but it didn't work this time because you did a good job.
I'm so messed up. I don't even know what I'm doing right anymore here. So.
Yeah.
Title of expert.
Okay. Have you ever been investigated for any
Well,
action?
hold on. But you didn't think to say, are you competent?
Yep. Okay.
Wow, that would have been nice. Yeah.
Right. I think I started to make a good point, but I didn't close the deal on it. That's the problem.
Yeah, man.
As a deputy in the sheriff's department?
As far as what I mean.
Just answer the question, sir. Yes or no?
I don't understand the question.
I'll repeat it then. Have you ever been investigated for any actions you have performed as a deputy in the sheriff's department? Yes or no?
This is kind of a waste.
Again, I don't know what
No,
you're
no,
going
no,
with this question.
You're not being clear enough for it to answer.
There's simple English
Yeah.
questions, sir.
I would have failed you on it too for not being clear enough.
Investigated? What does that mean?
Reportive investigation.
Yeah.
Investigation. What?
Have you ever been investigated by the sheriff's department? Yes or no?
Yes.
Yes, you have.
Ah.
Sure that
You
it
got
is.
a job there.
See, the judge actually did a little bit of his job. You noticed that the cop was being evasive a little bit, huh?
And you know why Paul did that? That's right out of Mark's script.
Well, that's a Brady, right?
Yeah, right,
But-
exactly.
But I didn't take it anywhere, and it was just a fart, That's all it was.
No. You have a Brady request in, correct?
Well, no, the judge. Remember, the judge denied my discovery request.
Yes. This brings up why that denial was an injury to you.
Yeah.
You should have had this information before the trial, and you didn't get it until cross-examination.
And the
Well,
cop
that's the
just
point,
said it.
because that question is in the list of discovery questions.
Yeah.
Yes, and Brady request is all about the fact that the prosecutor should have actually provided you that yes answer before the trial.
Yep.
Right,
And
okay.
Brady's a bigger issue than you think. I mean, Brady's almost as big as that other issue where he showed that he was already finding you guilty. The fact that he denied Brady and that you, in a simple cross-examination, discovered that he'd been investigated for wrongdoing by the sheriff's department.
That's sweet, dude.
I would make that a whole 2-pager.
Okay.
Fuck that.
Okay, well, excellent. I didn't appreciate the significance of it. I thought it was just, like I said, I thought it was just a fart in the wind, but I guess it was, thank you for clarifying that.
That's
This is information you should have to prepare, not last-minute bullshit,
Right, because
Send yourself
I could have challenged the competency of that witness more forcefully.
And you tried to voir dire and had been denied.
Yeah, wow.
Right.
So I bring that up too in your 2-pager about the denial of Brady linked with the denial of voir dire linked with this now sudden cross-examination issue.
Yep. Sweet.
Okay, right on.
I'm accused of violating the laws of the state of Wisconsin. Is that true?
Yes.
Do these laws apply outside the state of Wisconsin?
Irrelevant.
Sir,
It's irrelevant. We're not dealing with the laws outside the state of Wisconsin.
okay. Is it your opinion, Deputy O'Toole, that I was within the state of Wisconsin?
Yes.
Is that an arbitrary opinion, or is it based on facts currently within your knowledge?
Sir, his testimony was that he stopped you in the town of Lisbon in the state of Wisconsin. What more do you need?
Are you answering my fucking question?
That's your opinion. Judge, are you
No,
allowed?
that's not my opinion,
Just-
sir. That is it.
Are you giving
Sir, don't
evidence,
be
sir?
quiet.
Are you providing
Sir, be
evidence?
quiet. I am telling you what is in evidence. You have a Wisconsin driver's license. Now, we've already talked about that. You were stopped in the town of Lisbon. The deputy testified to that. That's in the state of Wisconsin. He testified with that. He is an employee of the Waukesha County Sheriff's Department. He was on duty. He had the right to stop you. He had the right to question you.
Objection! Holy shit!
Yep.
Right.
Sir, would you
Big
swear
time,
in before
man.
giving all this testimony?
Yep.
Well, I tried to call him on that, and he
But,
just...
hold on.
Go ahead.
Let's make something constructive out of this. I would make this triad of testimony that this judge is giving you right now that is not subject to cross-examination a whole 2 pages
Right.
of his demonstration of bias and his prejudgment of these issues before any testimony is even been given on it.
Yeah, there's a lot here.
Okay.
Sorry.
No, that's okay. I really appreciate your
The right to cite you for a violation as he understood it and saw it. And that's what we're here for, sir. Whether or not you are guilty of that. And I will make that determination.
Sir, are you providing testimony here today?
No, I'm not providing testimony.
Then would you let the deputy respond to my
I
question, sir?
certainly will. To a reasonable question. And you are being unreasonable, sir.
I'm asking
You're being unreasonable.
Objection, what's reasonable?
Matters in fact. We don't need to have it 16 times. It's been stated. I have clarified it for you. That is not evidence. That is a clarification. Judges have the right to do that.
And I have a right to seek the facts and evidence that
You do.
support.
You do.
And I'm-
Right to seek the facts, not to be argumentative and not
to be all over the place. Stick to the facts of this traffic ticket, sir.
What a prick.
Jesus, man. And not to be argumentative. What the fuck? You don't have the right to be argumentative, apparently.
Yeah, it was okay, let's let go here. I can't remember what happens.
That the codes and statutes of the state was.
This is let me just rewind it a second here.
Oh, you're killing me with the rewinding.
I'm sorry, I just I don't mean to.
Man, I want to do an impression of Tom right now.
Uh-oh.
That the codes and statutes of the state of Wisconsin apply to me because I'm physically
Irrelevant, sir. I have already stated that they do apply. I've made it eminently clear to you that they apply and you are subject to them.
Objection. Looking for evidence, not your opinion.
Yeah.
Proceed.
This is a burden prosecution has, not you.
Yeah. Is there any burden of proof on that issue?
Right.
And again, I'd make that a part of your ordeal with the suspension deal. But
Right, and as Tom was chiding me, I ended up saying, okay. I gave up and just said okay and moved on. It was a mistake on my part.
Objection.
Yeah.
OPOC has to be ingrained. I don't care if you say it too much. I do. I don't care.
Yeah.
I just rather
better
say
too much
object
than
than
not
not.
at all. I mean,
Yeah.
better too much than not at all because
Yeah.
we had very little.
Right.
Deputy O'Toole, did you file a valid cause of action against me?
Irrelevant.
I'm sorry, sir. Is this complaint not a cause of action?
It's a ticket. He issued it to you. What more do you need sir? How many times does that happen?
I need to get
Unresponsive.
an answer to my question.
Unresponsive.
He didn't
yeah.
say it was asked and answered. He said it was irrelevant. See?
Yeah.
Okay. I eventually get him to concede this point, so it's painful to listen to, but let's listen to it.
345, section 311.8. Would you take that judicial notice? Number 8. Any person who with criminal intent solicits or aids in the disposition...
Stop. Stop.
I'm trying to cite your statute.
Stop. You're citing the wrong statute. It's not applicable because this is not a criminal action.
I'm citing the traffic state in the code. It says that...
Criminal. This is not a criminal
I'm
action.
not citing a traffic... Let me finish.
You just read it.
I didn't even finish reading it, sir.
You don't have to. I don't need it. It's irrelevant.
It says attempted disposition of a uniform traffic citation in an unauthorized manner is in contempt of the court having original jurisdiction in the cause of action. The statute...
Criminal.
This is not criminal.
What did you read the first sentence? Read the first sentence.
Any person who with criminal intent...
You didn't have a criminal intent. It's not an allegation.
That's not the point.
It doesn't apply. It's not applicable. Stop.
How can it speak to your intent?
He's right.
It's not criminal.
Well, you're not accused of having criminal intent, so you're trying to bring in a statute that's not relevant.
Or not.
See, again, code pleading is very.
Hang on, listen. Bear with me. Just listen to. I listen to this for a second. Hang on, man. Don't talk over it. Just for a second.
Okay.
The first sentence.
Any person who with criminal intent...
You didn't have a criminal intent. It's not an allegation.
That's not the point.
It doesn't apply. It's not applicable.
It refers to the uniform citation as a cause of action, sir.
It's not criminal. Stop.
Is the uniform citation a cause of action or not?
Yes, but it's not criminal.
Okay, it's a cause of action. Thank you, sir. Judge, Deputy O'Toole, did you file a valid cause of action?
Objection. It calls for a legal conclusion.
Sustained.
Orchestrated bullshit.
Move to strike all legal conclusions from this witness.
Right on. See?
Oh,
that's what I mean.
I didn't quite get it. I get there slowly, but...
Fuck, you get him to make this, you get him to say it, and then you didn't know how to close it?
I know.
Dude, that's what I mean. This was the gem. I heard this. I'm like, dude.
Oh my God, you got him. Hold on.
It's just like Scarlett the other night when the judge literally said he doesn't have jurisdiction, and she let it go on.
Hang on, guys, hang on.
Objection. It calls for a legal conclusion.
Just listen.
Sustained.
Sustained. So now the deputy is not allowed to make legal conclusions. I thought just a minute ago he was able to make legal conclusions. Now he's not.
Sir, stop. You're wasting your time. You're wasting your time. The deputy has stated on the record that he stopped you. He had reasonable cause, in his opinion, to stop you. He issued you a traffic citation in person.
You're winning. You're
All
winning.
the things you've asked for are repetitious.
You're winning.
It's not going to happen, sir. You got the ticket. The
Yeah,
the question again?
You see, he distracted you from your question. Is
Yep,
he
what was it?
able to make a legal conclusion or not?
Right, and I come back to it, but not with the force and that I could have and should have. So
Because it's case dismissed after that. It's case dismissed.
He had you acting the way he wanted to. Fear, intimidation, yes, but he had you very much acting the way he wanted to, in a lot of respects. Not in all of them, you know.
Yeah. I made a good point, but I didn't close the deal, and
But you did make the point that again, moving to strike all the legal conclusions that this officer has entered. I get there eventually, Gary, but not with the coherence and the force that you just described. So let's just listen.
So he's not going to answer the question.
No,
without filing a valid cause
I
of action?
sustain the objection. He is not going to answer it.
Okay.
Yeah, calls for legal conclusion.
And what did I say? I said okay. And I know that bugged Tom, and it bugs me too. I shouldn't have
No,
said.
well, that part's fine actually. The fact that the cop's not competent to give a legal conclusion is a big win. The problem is you got to apply it not just on that one topic. You've got to get it to apply to all of his legal conclusions, not just the ones that help you.
Okay, I think I get there. So let's listen.
Okay.
Did I cause any harm on January 16th, sir?
Sir, that's not an allegation. The allegation is you were speeding, not that you caused harm.
Is this a civil allegation, sir?
Yes.
What are the grounds for standing for a plaintiff in a civil case, sir?
The facts.
And the sir? The facts of what, sir?
True.
That you were speeding.
Did I
or
cause
not
any harm?
speeding.
Did I violate anyone's legal rights or cause any harm, sir?
Yes, you violated a whole bunch of people's legal rights by speeding. In violation.
Whoa. He's testifying. Again, I'd make that a big issue. The ongoing testimony of the judge.
Right. And I asked him if it was hypothetical, and but I didn't really nail it there. But I come back to this other issue.
Well, the fact that he did it is enough sabotage to his own.
Yeah.
Okay.
I mean, he pronounced you guilty and then proceeded to testify against you.
Right.
If I was the prosecutor, I'd be pissed.
No, the prosecutor's tickled over there. Smiling.
Well, of course, but he's in one sense, if he had any idea what Paul is going to do to him in the future, he'd be pissed because he'd know this is going to come out and bite him. He's fucking up his case, all this.
That's a good point, Joe. That is something that Gary brought up last year.
But I would bring that up, and that would be a whole page.
The prosecutor wants to make sure
this judge testifying outside of evidence that was provided to him by anybody at all.
Okay, I'd like to finish. Oh, Gary just dropped off. That's okay. I'd like to finish that point. Gary pointed this out to all of us last year about how important it is for the prosecutor not to let the judge fuck up his case, because if he does, it makes
it's failure to prosecute.
Yeah.
What it all boils down to.
Yeah, that's a good point. How do you know that, Joe? How did you learn that?
Because he said it again like a couple weeks ago, or maybe I listened to it during an old YouTube video. It could have got it there too, man. I don't know where I'm drawing it from. I've listened to Gary talk so much, my head's spinning in the last 2 months.
Okay, well, you caught that. You caught that.
For real, dude.
Good. Well, anyway, well,
let's see if I think I eventually come back to that point about sustaining the objection that the deputy can make a legal conclusion. Let's see if it comes up.
Where is the plaintiff, sir? Where's the factual evidence that there's a plaintiff here with a valid cause of action for us?
Sir, I'm not going to address that. because that's argumentative. You have a ticket.
It's a question. Damn it! It's not argumentative. It's a question.
Yeah, I bailed out. I caved in here. I should have stuck to it because I had a great point and I didn't hold him. I didn't hold him accountable. So I dropped the ball there.
Trustee.
That doesn't mean you still don't get steamrolled. I did the same thing and just got steamrolled. So.
Well, so did he.
Yeah. Well, I mean, I brought it up and still got steamrolled.
Should I ask this off?
I have many things, sir. Yes, I do.
Okay. Now here we're going to get into some code pleading.
You said you were familiar with the ordinances of the town of Lisbon. Is that correct?
See, the problem is I gave up on the fact that I never did make the point that all of the assertions of the deputy, including the complaint, should have been thrown out because he was incompetent to make legal conclusions. I didn't. I thought I made that point, but I'm not hearing it here. And then I gave up on the fact that there was no valid cause of action, and it was like I went to the bottom of the barrel, and pulled out some shit about the typos and in the town of Lisbon ordinances as posted on the internet.
Forward to.
Well,
Go ahead. What was that?
I don't know who's going. Gary's going. Gary's going before anybody. Go, Gary.
Is that all we have to look forward to? Is that all there is, and then the guilty verdict?
Yeah. So if you guys want to call it a night, we can do that, or else we can just let.
Discussing that obviously is productive, but discussing code pleading isn't,
right. And
discussing how he found you guilty before he even started is.
Yeah. Oh, okay.
But I don't need to watch this long. No.
Well, it was a good night.
If you want, we can just call it a night here then, and what you can listen to the recording later. But what I go on to try to the point I try to make is that the town of Lisbon did not adopt the state statutes in strict conformity with the law, and it's kind of a shitty argument because. Go ahead, Gary.
You never tried that wedge between physical state and body politic. You never did.
Right.
I mean, you started to, and then you abandoned it, and then you started to do something else, and then you abandoned it. It's
I'm telling you, it was crazy.
Because you get resistance on the topic, and then you give up on it.
Yeah. And
then you get resistance on the next topic, and you give up on it.
Right, and that's what people can learn from listening to this is that when you got the fish hooked, you have to reel it in. You know, you got to stick to
confession before we move on. Yeah.
Right. Well, this might be a good place. It's been about 3 hours. This might be a good time to call it a night. And I got a lot of really important and valuable information from this recording. So
don't underestimate how much you have to write. You know, each of these small things that are easy to overlook. You know, the fact that he, said he had jurisdiction because of his election. The last thing he said, what was it?
That you had violated. You violated this.
Testifying.
Yeah.
And there was one element that wasn't even in the testimony that he brought out. You know, his continued show of prejudice.
Violated lots of people's rights by speeding.
Right.
Yeah. You violated lots of people's rights. Whose accusation is that? You were there you asked the cop that very question, and instead of letting the cop answer it, the judge answered it. How wrong is that?
Right.
So, Paul, you have a huge advantage for you going in here for you. I'm sorry. You just have a.
Oh, I'm sorry.
No, it's a delay. Don't worry about it. I'm just going to real quick that Paul has a huge advantage here in that you can make your mistakes serve you by coming back with motions and then at the next hearing being so ridiculously prepared and professional that you just knock this guy's socks off. He doesn't even recognize it's the same person anymore. And further, when you do that, not only is it you obviously affecting your life, but everybody else that's around is watching, and it's just a little heads up to the judge, like, hey, man, it's a new century. You're going to start getting this stuff more and more, and it's because of all this hard work you're doing, and it's just me saying thank you. And I think you're going to use that advantage well. He's not going to see it coming. He thinks you're an idiot. Paul, if you just like wrote down your question, asked it, and then no matter what the judge says, you make sure that question gets answered. If you did that one thing and that one thing alone, that would have probably cleaned up 80% of the mistakes that we called out here. Instead of letting him distract you.
Paul, you've gotten a lot better at this, though, man.
Here's a point that comes to mind, and I'm sorry, this might be useful. Well, it's all useful. This might be useful in what you're writing, is what I'm saying. It occurs to me that it pretty much is a denial of cross. The fact that he wouldn't let you ask that cop if you injured anyone, but answered it himself, was a denial of cross-examination.
Good point.
Because he was heading you off at the pass because you can't ask him cross-examination, and you tried. But he denounced it and started yelling at you for it. And you were left without the ability to cross-examine this testimony, the judge's testimony, because the judge gave it in the place of the cop, and that amounts to a denial of cross. And I would label that denial of cross, because that's one of the fundamentals.
Right on. Got it. Okay, well, I think that's this has been super valuable for me, and
everybody, dude, thank you.
Thank you, Gary, Joe, and Fabrice, and Stahl, and
Tom,
Terry, and don't forget Camille.
Tom.
And Camille.
Hey, Tom.
Joe knows, or Paul knows I'm around.
I know.
You have a
I just wanted you in the credits.
Yeah, it's okay.
Well,
I was too quiet. I was too quiet tonight.
Good being Tom.
All right, guys.
That's a gold star.
Okay, excellent. Hey, good night,
Don't
everyone.
get 2 gold stars.
Good night.
All right, thanks, Paul. You did well, I think.
I think you did beautifully, Paul.
Hell yeah, so far above average.
I think a
and
lot
don't forget, they were both on you, man. And the judge, I bet you they talked it over the weekend, having a couple of beers, and they said, we're going to screw him really well. You wait. No, it just sounded like the judge was there in it for you. He got all the background from the other judges, and he said, I will fuck him really nice. Don't worry, guys. I'm really good at this.
Well, and let's just finish the one point. When you go ahead and submit Mark's motions, you're throwing a red flag out. You're waving a red flag in front of the bull. I mean, they know they're after you, and they're gonna make they're not gonna be bowling pins waiting to be set up and knocked down. I mean, they are gonna be aggressive when you file the motions, and so that's part of it.
Yeah, and the Brady request. Oh my God, just keep coming back to the things that they steamrolled you on.
Yeah.
You had no follow up to the fact that he was investigated. You didn't ask him about what and for what.
Yeah, you're right, Gary. There was a lot of room
because you didn't have any opportunity to prepare.
And the judge kept jumping in and getting him off point.
Right. Yeah. Okay. Hey, and enough for tonight. But thanks again, everybody, and I'll get this posted real soon.
All right.
Probably not until Wednesday.
I started this call, right? This is Tom.
Yeah, Tom.
Okay, cool. It held on. Great. All right. I'll talk to you guys. I'm going to hang up now.
Thanks, Tom.
Right.
Bye.
Bye.
Good night, everybody.